Welcome everyone. This is the last session of the July 2023 Florida Bar Crash Course. And I have done a lot of teaching this administration. I did a complete MBE crash course. Matt and I did a complete UBE crash course, which was actually our most comprehensive course. It was a 46-hour course. This course ended up being about 35 hours maybe. And I'm happy to report that of my MBE, UBE, and Florida courses, which occurred on Monday, Tuesday, Wednesday, Thursday, twice on Saturday, twice on Sunday, never missed a single session. So I'm very accountable, and I think accountability is the key to life. The other key is positivity, and we just spent a good amount of time just feeling good about life and trying to forget about what's ahead of us, but not forget about it, but just approach it in a more positive light. What shall be, and it's just a test. If you have to come back and retake it, everyone in this course has free access to my course next administration. I really hope we'll have perfect passage rates, whatever it takes. I do know that from looking at my statistical analysis of my team and my students and all different things, the students who work with me extensively are the ones that I feel the most confident in. And that's just a testament to me doing this full time, whereas most people or tutors moonlight. This is my jam. So we did every single subject on the calendar, and it's nice to kind of pat ourselves on the back and see what we did. We did contracts, we did torts, we did con law. And remember, con law is federal, Florida, and criminal. So it could be 4th, 5th, 6th Amendment, all that stuff. And then Florida, Sunshine, Homestead Law, federal, 4th, 1st, 14th Amendment, all these different factors. Talked about real property, which I have a feeling is going to be tested. I know that's like not a bold statement because there's not that many subjects that can be tested now, but I do feel like property is coming down the pipeline. And we should be excited because property is actually the most interesting area of law if you're interested in becoming wealthy. Someone on a plane once told me, people who become rich in life buy and sell property. People who become wealthy buy property and never sell it. So think about understanding property law, not just for passing the bar, but for becoming a wealthy person. We did multiple choice subjects, and I've shown you all the Thinkific site, ibisprep.thinkific.com. You can just roll through the Florida multiple choice questions and answers and make sure you're doing the official FBBE ones to a T. And ideally, you could memorize all these questions. We did the proctored exam. I think all your essays should have been graded by me or Amy. If anyone has any outstanding essays, I have free time today. I got time today. So message me and I'll make sure they are graded myself. I kind of assigned, get it, assignment. I assigned the, actually, no, I delegated, let's be clear. I delegated the duty to Amy to grade some of the essays. So if you didn't see the humor that I usually have in grading essays, which is not much, but it's just because some of them are graded by Amy. But hopefully they should all have been graded. If not, I will take on my assignment. Just because I'm the original party, I still am liable. So I will absolutely grade any essays necessary today. And now that leads us to the review. The review, we did, oh wow, we did that PowerPoint where someone messaged me and said, are you on Adderall right now? I don't know if that was a compliment or backhanded assault and battery, but I'm definitely not. I definitely could have been prescribed it as a child, but I don't like to use that. It makes me depressed whenever I tried it when I was younger. So anywho, review, and then final review 11-1. I think this review, in my opinion, is the most valuable thing I've ever done in the history of teaching. I went over all 69 official questions with the explanations. We did get 2 questions wrong. One of them actually wasn't my fault. I stepped away and someone clicked it, but whatever. I'm so funny. Okay, and then final review is today. And we're gonna get into the final review. And what's most important about today? Essays, subjects, essays. What separates Ibis prep students from everyone else? Essays. Essays carry students. Essays are where we have the most room for separation from the pack. You're just filling out circles the rest of the test. You're a robot. But this part, there's a little bit of humanism. There's a little bit of creativity. There's a little bit of thought. There's a little bit of reaching for rubric points. So I want everyone to master essays and feel like if you studied with Ibis Prep, you became a master of how to write essays. I'm telling you, I have personally scored insanely high on Florida bar essays. And I'm about to take the UBE, and my plan is to score insanely high on the UBE essays. I know what I'm doing when it comes to writing essays. When it comes to teaching multiple choice, you know, I'm doing my best out here. When it comes to teaching essays, this is what I was put here to do. I've always been a great essay writer. I have an English major. I went to law school. You know, my mother was a librarian. I really understand how to write essays. So the thing that I want everyone to rock with me today, the last folder that we're going to check as a class is, in fact, without further ado, the official essays and model answer folder. And we're going to run through this like madmen today and leave no stone unturned. I will let there be some fun in the class, because F is for friends that do stuff together. Omar, you are the Forrest Gump of my class, and I'm going to use you as an example of how the alignment between mental and physical health for the rest of my life. But which subject do you want to start with on this test? And try not to pick one that's actually a multiple choice subject.
Any subject you can pick.
All right, I like that. Let's start with the old faithful, contracts. So what we're going to do is we're going to do it my way. And I know people say, oh, Andrew, I want to do it this way. This is the most valuable way. Trust me, I know what the most valuable way is. Just like if I was working with Angel, my boxing trainer, I wouldn't tell him how I'm supposed to do a punch. I wouldn't tell him what drills we should do. I would just shut up and listen. And I'm not trying to be mean and say that. I'm just saying what I would do. If I did have a question, I would certainly ask it, but, you know, politely in the chat and let, you know, the instructor do his thing, because he's turned me into a really good boxer. I could turn you into really good essay writers if you just follow my process. All right, so maybe we did this one. Who cares? We're going to leave no stone unturned. First thing I'm looking for is, what are they asking here? A memorandum that talks about claims and defenses. No discussion of damages. Alert, alert. We are not discussing damages. Okay, without even looking at the essay, I can get probably a passing score. I really believe that. I can get a passing score in this essay without even reading it. Why? Because I know it's about airline v. oil company. I said they didn't say damages. Okay, I had to read the first sentence to know it was a contracts essay. But now that I know it's a contracts essay, I could pass it, right? How do I know I could pass it? Because there's certain things that come into every single contracts essay that's ever been written. If you have a handy dandy pen or pencil, Omar, I don't know what it is that you're using to document, but I'm sure it's 2020, 2023. You could use some lasers or something. I would write down and try to follow me. Maybe your hand's going to get tired or cramped writing today. So is it going to be on Tuesday? Let's rock with me here. So why am I going to get 80 points? Because I'm going to ask myself, what is a contract? A contract is an agreement between two or more parties in which there are valid remedies at law. The next question I'm going to ask myself is the contract governed by the UCC or is it governed by common law? If it's governed by the UCC, it's going to be for goods. What are goods? All things movable. If it's governed by common law, that's going to be land, services, and everything else. It's important to note whether the parties are merchants. Why is it important to know whether parties are merchants? Because under the UCC, there are special rules that apply to merchants, such as the firm offer rule. There's no additional consideration necessary for a modification. There's the firm offer rule. And if I said that earlier, it's because I also meant to say the bow of the forms provision and the knockout clause. There's the, if you have a anticipatory repudiation, they'll have 30 days to request further assurances. There's the perfect tender rule. There's just a lot of rules that apply to merchants. So for me, it's important to note that they're merchants here, because maybe one of those rules will apply. Okay, now that I've determined the issue of, is there a contract, of what is a contract? I've determined the issue of what body of law will apply here. What body of law will apply? I don't know, it seems to be jet fuel, right? Seems like good, UCC. Okay, so here the UCC will apply because it's a goods over $500. Now, immediately, we have to talk about contract formation. Offer, acceptance, consideration, no valid defenses. An offer is an intent to be bound by the terms of a contract in a way that the offeree could accept. That gives power of acceptance in the offeree. And acceptance is an assent to the contract. There must be mutual assent and a meeting of the minds, let's say, for there to be a contract. Mutual assent, meeting of the minds, and intent to be bound by the terms are some of the buzzwords that I'm going to make sure I drop in there. There has to be consideration, which is bargain for exchange of legal detriment or value in Florida. And there has to be no valid defenses. Here, there is an offer when la-di-da-di-da, there's an acceptance when la-di-da-di-da, there's consideration when la-di-da-di-da. Now we need to talk about defenses. What's the main defense we're always going to talk about? You nailed it, the statute of frauds. Under the statute of frauds, there are certain contracts that must be evidenced by a writing and signed by the party to be charged. These contracts include marriage, contracts that cannot be completed in 1 year, contracts for land, executorships, goods over $500, and suretyships. There are exceptions to the statute of frauds, including swap, specially manufactured goods, written confirmatory memo, admission in court, partial performance, and promissory estoppel. Other defenses to contract: mistake, unilateral mistake. Mistake, if it's mutual, will void the contract, or the remedy of reformation could be appropriate. A unilateral mistake, the mistaken party will have to bear the burden of that mistake unless the non-mistaken party knew of the mistaken party's mistake and essentially took advantage of them. So we have mistake and we have statute of frauds. What are some other defenses? Well, now I'm thinking about a whole lot of I's: illegality, illusory, incapacity, impracticality, impossibility, infancy, improper purpose. I don't know, some others. I would think if I had a pen and paper, I'd write more of them. Unconscionability, and then maybe duress, fraud, misrepresentation. A lot of defenses to contract. Now we would say, but here, you know, la-di-da-di-da, therefore there's likely a contract between the parties. I don't know this essay from a can of beans, but I'm sure there's a contract between the parties, right? Because if it's a contract essay, you're going to arrive at a contract. So I talked about, is there a contract? I talked about body of law. I mentioned the importance of merchants. I talked about offer, acceptance, consideration, no valid defenses. Ooh, I need to circle back, because did I talk about mirror image rule? Did I talk about firm offer? Mirror image rule, if it's common law, even though this seems to be UCC, I'll still get a point for saying if it were common law, we'd use the mirror image rule. But this is going to be, let's assume UCC. I haven't read the essay, but let's assume this is UCC. We're going to need bow the forms provision, where an additional term will be considered part of the contract unless it materially alters the contract, or the offerer explicitly rejects in a reasonable time, usually considered 10 days. So we talked about some of these things. Maybe even at the top, when I'm just getting points, I'll talk about the predominant purpose test. Is it UCC or common law? Well, if there's, you know, if this is, you know, I didn't have read this essay, but if it's UCC and common law, there's goods and services, we'll apply the predominant purpose test. Shoot, I'm getting a lot of points up here at the beginning. Maybe it's a divisible contract. I can argue for divisibility of contract. I already saw requirements, so I'm going to define a requirements contracts versus an output contract, right? Like I'll buy all that you produce, or I'll supply all that you require. And we'll talk about the validity of them and how those contracts don't need the essential terms. Do you see how I'm just jogging my memory? Those contracts don't need the essential terms. Well, I talked about UCC earlier. I might as well have talked about the essential terms under the UCC. The essential terms have to include the description of the goods and the quantity, but not necessarily the price. We can use UCC gap fillers. So talking about all these things at the beginning, just, hey, what kind of contract is it? Who are the parties? Has there been valid formation? What are the defenses? Is it, like I said, requirements? Is it an installment contract? You know, like, is there an exception to the perfect tender rule? I definitely want to use that word, perfect tender under the UCC, substantial performance under common law. Has there been such a occurrence? And then firm offer, is there a firm offer here? Is it going to be between merchants, so it'll remain irrevocable for 90 days? Is it going to be an options contract, which would require consideration if it's not merchants? You know, what kind of contract are we dealing with right here? Get into all those points. Then there's got to be a breach. I'm sure one of these companies breached the contract. Oh, wait a minute. I actually just looked at the question for the first time and I saw the word mail. Okay, it's going to be mailbox rule. Hello. Doesn't take Kim Kardashian's tutor to know that, right? I'm stuck on it. That's another of my flaws. I get stuck on certain weird things. But anyway, it's the mailbox rule. And the mailbox rule is pretty simple, right? Offers are effective upon receipt, everything else upon dispatch. But if you send an offer and then revocation at the same time is whatever's received first. Yeah, mailbox rule. That was easy. I spotted that issue. It took me 5 seconds to see the word mail. I see the word oral, statute of frauds, right? You have to read these essays like I'm doing right now. Yes, you need to read it carefully, but you also need to read it as a very efficient spot checker. I always tell people this about my job. People are like, oh, you charge so much by the hour. I'm like, I should not charge by the hour. I'm killing myself, because charging by the hour encourages me to slow down. So, you know, oh, you need to do more sessions? No, working diligently encourages me to get people to where they need to be as quickly as possible and get results. That's what doctors do. You go to a doctor and the doctor solves your problem and you're happy that it's done fast. So I'm transitioning into that. You know, I'm going to be more of a results-based business than an hourly business, right? But what am I telling you all right now? That when you read through these essays, there's buzzwords that should jump out to you and should force you to recite rules of law. If you see the word orally in a contract essay, it's definitely implicating statute of frauds. If you see the word mail, it's most likely implicating the mailbox rule. If you see the word minimum quantities, it's most likely implicating requirements or output contract, right? If you see the word firm price, you know, it's probably implicating firm offer, you know? If you see money, it's probably implicating UCC statute of frauds, whether it has to be in writing or not. If you see canceled all other negotiations with other suppliers, that's reliance, right? In reliance, justifiable reliance, promissory estoppel, like all these things just have to jog your memory. People think that I'm like, I don't know what people think about me, but there's a reason that I do the albums of the year. There's a real reason. And there's a reason I chose my album, not just because Ill-Gotten Gains is the coolest rapper name ever, but because I can go through a whole system of new albums. Ill-Gotten Gains Restitution is my first album. Ill-Gotten Gains Quantum Merit is my next album, is my current album. Ill-Gotten Gains Unjust Enrichment is my album after that. Ill-Gotten Gains The Quasi Contract is my album after that. Do you see that? Like how I'm actually thinking down the line? What really helps students is vocabulary. And if you can understand the similarities between Ill-Gotten Gains, Restitution, Quantum Merit, Unjust Enrichment, and Quasi Contract, that's crucial. Those are 5 really smart words that I just used, and I just blew the reader's mind away with my knowledge of the law and my ability to use proper legalese. Like if you meet me, I was born in Miami, I grew up in Philadelphia, and I went to school in New Orleans. My lexicon is not that proper, but certainly when I write, I sound like Billy Shakespeare, right? Because people don't hear my voice when I speak. I can't say things that I can say. I can't say the word, oh, this John over here, right? I can't write that on a paper. You have to write your papers to a reader who's very learned, who's a judge, let's say, and write a very sophisticated manner and use legal jargon to the best of your ability. So if we continue through this essay and just my thought, oh, there's definitely a breach here. There's always a breach. They wouldn't give us a contract question without a breach. There's got to be material versus immaterial breach. And we got to discuss the differences and when, you know, you're liable for damages and what maybe there's an anticipatory repudiation. Just jogging my memory of my little, you know, chart. I don't think there's a non-compete agreement here, but I'll certainly look for it. I don't think there's a liquidated damages clause here, but I'll certainly look for it. Anticipatory repudiation I already talked about. Installment contract I already talked about. And then parole evidence. I think parole evidence comes in a lot of essays. It's just like something you can probably talk about. Like if there was any evidence that was oral, probably wouldn't come in unless it was to show a defect in formation, let's say a condition to the contract to clarify ambiguous terms or to show trade usage or something of that nature. So now refuse to fill the orders. What does that sound like? Breach, right? Refuse to fill the orders, breach. Now, what's the last thing I'll mention on this essay without me reading it at all? And I blew this essay out of the water without reading it. I hope you guys see how I did that. I didn't read any of these facts, but I guarantee I spotted 90% of the issues because it's that obvious. What does refuse to fill the order mean? It means you breached. Now, what's the most important thing? IRAOC, issue, rule, analysis, opposing argument, conclusion. If I turn my hat around, I'll give the opposing argument every time. Don't pigeonhole yourself into a conclusion, especially because that conclusion could be correct. These questions are harder than you think. Give the writers more credit. They didn't just give you a super duper layup. They gave you something that can be argued. These things wouldn't go to court if they weren't debatable. So please debate. And when you debate, you don't know what side you're going to be given. When you debate, file the IRAC form, issue, rule, analysis, argument, opposing argument, conclusion, weak conclusion. On balance, the court will likely find. All right, let's see if I hit any of these issues. Offer, acceptance, consideration, valid, no defenses. Point for me. I got 4 points already. Common law for services, UCC for goods. I got 6 points already. UCC is going to be for goods. I got 7 points. I said goods are all things movable. I got 8 points. I got 1 more point than him. His offer and acceptance stuff, I like my stuff better. I'm giving myself at least 3 more points for that. The minority rule of benefit or detriment, I haven't missed a point. Right, doesn't have to serve right. I don't know. I got more points than him. I'm winning. Me versus him, I'm winning. I didn't read the essay. All right. A request for information. Okay. First thing I missed, I didn't read the essay, but certainly make sure you understand that. Does it have a port swing? Doesn't mean I want to buy the house, right? It's just a request for information. All right, now we're back tied. Valid offer, firm offer rule. We talked about that, 90 days unless it's revoked. I talked about that. He's going to hold it open for 1 year. La-di-da-di-da. The mailbox rule, I talked about that. I don't like this guy. He confuses people with some BS. Requirements contract, I definitely talked about that. Another thing, my essay would have been way prettier. My one have said to, from, read, date. This essay will discuss the following issues. The issue here is like, I know how to write an essay that's beautifully written. I'm sorry, like I don't know how to, I'm not a fashion king. I don't know how to put an outfit together, but I could put an essay together and this isn't it for me. But this is the model answer. So I'm just telling you, we can strive to do better than the model answers. I've already done better in my head. So output contract I talked about. I would have definitely made it like output contract, definition, rule, analysis, conclusion, instead of just like, here we go, output contract. I'm not trying to be a hater. I'm just trying to be very much like, we can do better. We're pushing for greatness. We're not trying to just make it to the playoffs. We're trying to win the championship, right? All right, so let's see, valid contract in the UCC, talking about this or that, argument. I would have talked about an argument, like giving many points I didn't get. It can only be revoked before acceptance, revocation when received. So breach of contract. He talked about maybe divisible contract, defenses, promissory estoppel. I definitely mentioned that. I see how I said relied on it. Promissory estoppel. I made that connection like, I don't know, something that connects like that, right? Promissory estoppel is an equitable doctrine for enforcing a contract when one party relies to his detriment on the promise of another. Excellent. Substantial performance, right? I talked about his exceptions to the statute of frauds. Do you see why he hit a single and I hit a grand slam? He said, substantial performance is not right. I said, the exceptions to the statute of frauds are specialty manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. Here, the most applicable one is partial performance, and then I would get into that. Did you see how I wrote that? I could write as fast as I spoke it. If you're a fast typer and a fast thinker, that will certainly help you on the essays. I hope you guys are seeing why that works and why you need to have my mindset of just like, go, 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 Energizer Bunny, like, let's get all these points. I'm killing it. Whatever. I didn't see that essay. No one else did. I saw this essay, positive reinforcement as you're taking this test. I knew I was crushing this essay. And look, I crushed this essay. I would have written a way better essay than this. We have a valid contract. So then requirement contract, just making arguments. Mailbox rule. I don't like what he says about the mailbox rule. I don't want to get into that. Impossibility of performance. Okay. You said one impossibility. I said impossibility, impracticality, illegality, incapacity. My eyes run deep. I dotted all my I's and crossed all my T's. That's what I'm talking about. That's what I, with an I, am talking about with the T. All right, that was weird. Statute of frauds, whatever. Anticipatory repudiation. Yeah, right. Did he say the words clear and unequivocal? No, trash. I got more points than him. All I'm saying is strive to do what I just did. We can destroy these model answers. I didn't even read that essay. And my essay, which I just articulated orally in 15 minutes or less, put this thing to shame. And if you don't agree with me, please don't submit a poll telling me why, because I don't need that. But I feel like that's how you dominate a contracts essay. Let's pick another one and see, like, all right, what are they talking about here? Do you think it's the exact same thing, more or less? Absolutely. What do they say? Albert, causes of action, defenses, damages. What are we rocking with? Applicable law, UCC versus common law, offer, acceptance, consideration, no valid defenses. What are all the defenses? How many did you name? Inadequate consideration, mistake, duress, incapacity, intoxication. None of those apply to this fact pattern. Do you see how I do that? But I do it way better. I'm not trying to like brag, but I'm just saying we do it better. If I do it better, you do it better. I want every one of you to beat my score. I think I'm going to get a great score in the UBE, but to be fair, I've been working like a dog. One of my students said that, Andrew, you work like a dog. I love dogs, so I didn't take offense to it. But like, yeah, I work. I just teach. I don't really study. Y'all been studying. Would I love for my students to outperform me on the test? Absolutely. It's like when the home run king gets his record broken, Dan Marino, all his records fell to Brett Favre, who all fell to Peyton Manning, who all fell to Tom Brady. Like, that's just the way it goes. You want people to outperform you. I'm giving you the things that I didn't have. This is, I don't want to say trash. You named 1, 2, 3, 4, 5, but I could have named 12. 12 is more than 5. I teach math if anyone's studying for the SAT or jury. All right, defenses to execution. I don't know, some more trash, like you just have to have the exact terms. Installment contract, I already talked about this in the last essay. Remember, installment contract, a breach, you'll most likely have an opportunity to cure unless it's material. Like, if it's the bakery example, you needed the bread for Monday because you're going to cook on Tuesday. Well, then delivering the bread on Wednesday, even an installment contract would amount to a material breach. This right here, I talked about this, always talk about this. This should always come into your essay, material versus immaterial breach. It's an easy discussion to have, but it's a very relevant discussion to have. Perfect tender, right? Think about this UCC versus common law. UCC, you need less definitiveness at the beginning, precision at the end, right? You have the battle of the forms provision at the beginning, perfect tender at the end. In common law, you need precision at the beginning, mirror image rule, and then less precision at the end with substantial performance. That's a good way of thinking about it. They amount to pretty much their equal opponents. You have to be precise in the offer under common law. You have to be precise in the delivery in UCC. There's a little bit of wiggle room in the offer and acceptance at UCC. There's a little bit of wiggle room in the delivery at common law. I hope that clarified anything. I know the chat room is booming right now. I usually take that as a good sign, like people are learning, but I just haven't been able to look at it. I'm sorry. I'll check it after I do contracts. All right. Impracticability versus impossibility. Now we're talking about the I's, right? Anticipatory repudiation, adequate assurances. Did he say clear and unequivocal? There we go. He said unequivocal. I would say the word clear and unequivocal, right? Now I like this. Okay. This is how you get points. This is the one thing that I can improve upon. I think I'm very articulate and I know how to explain things. I don't have photographic memory where I could just be like element 1, 2, 3, 4, 5. I'm more just like kind of poetically weave my way through it. They do reward this. So if you are more photographic in memory, try to print your photograph on the paper, right? If anticipatory repudiation occurs, then the non-breaching party has 4 options. Treat the contract as total breach and sue immediately, wait for the performance date and sue, treat the contract as rescinded, or do nothing and encourage the other party to perform. La-di-da-di-da. Damages. So this one does talk about damages. This is good. All right, let's hear my damages piece. I would have already written this at the way beginning. In contract law, there are 2 types of damages, legal and equitable. Legal includes compensatory and punitive. Punitive damages are rare in contract law. It has to be super messed up. The main type of compensatory damage would be expectation. Expectations put the non-breaching party in the position they would have been if the contract had been completed. There's also incidental and consequential damages. Incidental need to have been foreseeable at the time the contract was completed. Incidental are damages that are related to recovering for the breach. You can also have lost wages, lost profits, an act of restitution, as I discussed, to disgorge ill-gotten gains. You could have, some other monetary types of reliance damages, let's say, would be legal. And then there's equitable relief, which is, non-monetary relief. We're talking about specific performance for land or unique art, potentially like injunctive relief or reformation or rescission or promissory estoppel or quasi-contract. There's kind of a gray area of, are these quasi, my whole album, my whole name, is that legal or equitable? I kind of think that my album, kind of like with everything I do in life, it's kind of in the gray area, kind of straddles the line a little bit. It's kind of a little bit different. So I'd put my box of albums in between legal and equitable relief in your head. And not all professors will agree with me on that exact classification, but I think it's fair. Legal relief is monetary. Equitable relief is equitable. And then if it's kind of a mix of equitable and legal, then it's probably the name of an album by Ill-Gotten Gains. Okay, so we talked about damages. Like they said, consequential, available at the time of contract. The damages were foreseeable. I definitely use that word, foreseeable, consequential. That's a perfect match, right? Just like if you're doing Civ Pro, you would think of a summary judgment with no genuine dispute of material fact. You know, you want to be very clear to use the matchy words. Matchy. All right. Here they're talking about duty to mitigate. Definitely a duty to mitigate. Talk about mitigation. You know, you have to mitigate contracts. Act in good faith. Definitely act in good faith. Equity, they talk about a little bit. Lost volume, lost profit, mitigation. Easy essay. I think contracts essays, I don't want to say they're easy because I think I come from a family of contract lawyers, so they make sense to me. But I don't think they're trying to be too deceptive. Let's look at one more to issue spot. I hope that people are finding this valuable because I think it is. All right, Sunco. That's a cool name. Oh, Cool Shades. That's a cool name. If you're going to start a business, be very, very, very thoughtful about the name of your business. Ibis means a lot to me. You know, my grandfather and I used to birdwatch, and he born and raised in Miami. There's ibises here. Ibis is the first animal to, the last animal to leave when a hurricane approaches and the first to return when a hurricane comes back. That's why it's the toughest animal in Miami. And it's also the mascot for University of Miami, where me, my uncle, my father, my grandfather, we all went. So the Ibis is very meaningful to me, but every day someone says, hello, is this Ibis Prep? I'm like, oh my God. Or, hi, is this IBS Prep? I'm like, you think that I name my business Irritable Bowel Syndrome Prep? Like, what are you talking about? And then I had a client in Australia tell me that in Australia, the Ibis is known as a bin chicken, which is like a trash chicken. So anyway, be careful with what you name. If I was going to name a business now, I would name it something very related to SEO, search engine optimization. Like obviously I would have every department named Florida Bar Tutoring Inc., LSAT Tutoring Inc. Like whatever people are going to Google, that's what you want to name your business. All right, enough about my business advice. Let's talk about this essay. So, oh, is she a minor? That's important, right? Think about major, if they're a minor or they're, of age, capacity. Think about salary terms. Like, you know, if it's a contract for employment, you definitely need to have salary terms. Parole evidence, it looks like, is coming up here. Non-compete, right? Non-compete needs to be reasonable in geographic scope, duration, and subject matter. Anyone wants to write down this little factoid? 5 years for patents is the non-compete. For the first time in my career, I had a non-compete issue. I didn't enforce it, but I was forced to rewrite my non-compete based on one of my employees' deep, I don't want to say misunderstanding. They certainly understood, but they're attorneys, and attorneys are the #1 people in life who think that they can void contracts. It's just like therapists are the people who need therapy. Massage therapists are people who need massages. Tutors are the ones who need personal training. Like people in life insurance agents are the ones who do life insurance fraud. It's like attorneys are the ones who like break contracts because they think they can, and just watch out for that in your career. All right, anyway, we're talking about non-competes, and it has to be reasonable in geographic scope, subject matter, and duration. Talking about social media, Abby's an influencer. Watch out for that. The Florida Bar loves to drop just random things to sound cool. Like Jake Pale was hanging out with KSY, and they were, you know, they try to like make you associate with random things for no reason, just to kind of throw you off. Like, don't let them do that. They're just weird. Not as cool as they think they are, trust me. All right, so let's just see what's going on here. I know it's non-compete, governing law always. Do you see how every essay starts the way I send it? What body of law is it? Is there a valid contract? And always goes with yes, there is a valid contract, or a contract will be enforced, because we got to continue writing the essay. Offer acceptance, consideration, no valid offenses, statute of frauds, we nailed that. Consideration, material breach, substantial benefit, minor breach, minor performance. Nothing new here. Minor breach versus major breach. So you have to actually talk about that. All right, this is about a sign, written, unconditional, promise to pay a fixed sum of money with or without interest, on demand or definitive time with no additional undertakings. You got to watch one of my videos from like 2 years ago. We turned this into a whole song, and my tutor now, Will Watson, was a fixed sum of money. But this isn't about UCC, so don't worry about that. All right. Anyway, just so we're clear, UCC Article 3 and Article 9 are supposed to be tested as multiple choice subjects. So that's why I skipped that. All right. Defenses to formation. I already named way better defenses in this essay. Parole evidence rule we talked about. It bars extrinsic evidence from before contemporaneous to formation from coming in as a term to the contract. If it's a final integration, which is a merger clause, then these are some things that may come in. Industry standard, course of dealing, or defect in formation. I feel like I mentioned all that. Here, common law. Remember, you can't force someone. Like, if I didn't tutor, you guys couldn't force me to tutor. I'm not a freaking, service ape on a string. You can't just force me to do indentured servitude, but you could get monetary relief. When could you get specific performance? Sometimes in payments, if it's like a lifetime payment plan. If you're going to pay someone for life and then you breach it, you actually will probably be ordered to specifically make payments. Why? Because it's too indefinite to know how long they're going to live. But usually specific performance is reserved for land or unique art. Promissory estoppel. See, they tested this a few times. Make sure you understand promissory estoppel. I wish y'all made more albums. We could have had more visual associations. I really do think that's valuable. Next July, February, I'm going to require it. Like, you have to make an album or you're not allowed to class after like the 3rd week. Okay. So what about covenants? Non-competes. Got to be in time, duration, and subject matter for sure. 6 months is presumed reasonable. That's what we say in Florida. Over 3 years is presumed unreasonable. A lot of them end up being 2 years, but you have to look at the contract itself. All right, that's enough with contract. I mean, obviously I would tell everyone to do this. Open up this folder, go through every one of them, issue spot it until it's so repetitive that you're just saying the same issues over and over and over again. All right, let me take a moment of silence. So someone feels the same way about Red Bull as I do about cranberry. Yeah, I can't drink Red Bull. Gross. Capricorns, what's up? Sagittarius, like Nicki Minaj. Give me all the Addy. I don't know what that means. I'm not in tune with coolness. No, I do not. I'm just kidding. It was a compliment. All right, bet. Great way to begin a PR section. Oh, zooming in, Charlotte. Sorry, Scarlett. I couldn't zoom in because I didn't see that, but I'll zoom in for the next one. There's no heading or memo here. Yeah, you don't have to do that. I told you why I do that. I do it because I have anxiety. Like, I still have my anxiety thing from day one. This is my token for this course this year, right? Like, I'm going to take this. Actually, it probably won't let me take it in the test. I don't know, but you know what I mean? I do that to get my wheels turning. To, from, read, date. This memo will address the following issues, and then I structure it out. Why? So I don't have to think. I can just start typing. You don't have to do that. Great contract offenses are statute of frauds, duress, impracticability, mutual mistake, unilateral mistake, impossibility, improper purpose, unconscionability, fraud, misrepresentation, so on and so forth. There we go. That's what I'm talking about. Correct damages statement. There are legal contract damages statement. There are legal relief and equitable relief. Legal relief are injunctive and specific performance, which are not available in service contract. Equitable relief is available in contract breach for expectation damages, consequential damages, reliance damages, and any further relief the court may find just, and so on. Natalie dropped in amazing rules, like always. Natalie's been amazing. Hopefully she's going to be an ambassador of Ibis Prep. If you all love my company, we're definitely looking for ambassadors. We did really, really well in sales numbers for July, but for my company, July is a much smaller historically sales season than February, because until now, we've been mostly a retaker company. Now I think we've established ourselves as the company from day one, but we'll see. So anyway, thank you very much. That was super helpful. And Natalie and Hannah and everyone who's been dropping, amazing resources, keep dropping them, because like King Solomon said, the world of the generous grows larger and larger. All right, so we looked at contracts. I know I said I was going to ask students to make it fun, but then I remembered my slogan this time: zero fun, sir. So let's not do any of that. We're going to go right into torts. Torts is the easiest subject on the bar exam. Why is that? Because what's going to be on a torts essay? The kitchen sink of torts. All the torts you need to know, right? So there's negligence, and then there's intentional torts. So you're looking out for the intentional torts: assault, battery, false imprisonment, trespass to land, trespass to chattels, conversion, intentional infliction of emotional distress, intentional interference with a business relationship, malicious prosecution, intentional misrepresentation, the privacy torts, which would include intrusion upon seclusion, appropriation or misappropriation, and disclosure of private information. It could also include defamation because there could be some elements of intent. There could be, anything that's intentional, this or that. It's like intentional, I don't know. If anyone could think of one I missed, drop it. I did pretty good on that. All right. And then there's, negligence, duty, breach, causation, damages, right? Make sure you establish the duty of care. The duty of care is going to be a similarly situated person under an ordinarily prudent person in similarly situated circumstances. What would they be called on to do? Breach, there has to be actual, but for, proximate, foreseeable, or zone of danger. Duty, breach, causation. Duty, breach, there has to be a breach, obviously. And then damages, right? Consequential versus, compensatory versus punitive. Remember some things you always say on every Florida torts essay. You ready for this? Write this down in big letters. Florida is and this is the first time I get to say this, a modified fault state. Modified comparative fault, right? I said that right? Modified comparative fault. I got it because I'm taking the UV. I tricked myself. Modified comparative fault. I used to say something different last semester. Modified comparative fault, which means that if a plaintiff or if any party is over 50% at fault, then they cannot recover. So you're barred from recovery if you're over 50% at fault. It's called modified comparative fault. That's the first statement. Florida is a modified comparative fault statement. Anyone over 50% cannot recover. The second statement is Florida has abolished joint and several liability. The third statement is in Florida, punitive damages are limited to 3 times compensatory or $500,000, the greater of the two. Those 3 are coming up on every torts essay. I told you what all the intentional torts are. I told you what negligence is. And when you say negligence, there's always negligence. What is negligence in a nutshell? That could have been an album, negligence in a nutshell. Negligent in a nutshell is someone doing something stupid, right? Period. Someone doing something stupid is negligence in a nutshell. If I'm not looking at the camera, I'm just looking at my dogs potentially being negligent, and Rosie, depending on what neighbor you ask, potentially being strictly liable. So I wish I could edit that out right there. Slip of the tongue. Rosie, you're perfect. Don't worry. You didn't hear that. So yeah, someone did something stupid. There's always negligence, negligent hiring, negligent entrustment, negligent supervision, negligent design, negligent manufacture, negligent anything, training, just like negligence comes around in every torts essay because someone always does something stupid, right? So we have the intentional torts, we have negligence. Now, what are the 3 torts that I know come about the most on Florida bar essays when it comes to torts, in my opinion? I say I know, and then I say in my opinion. It doesn't sound very credible, but it's in my opinion. Defamation. They love testing defamation. Why? Because it overlaps with con law. You have the public figure where it has to be actual malice, right? They love testing products liability. Why? Because it's a pretty tough thing to articulate. A supplier, retailer, distributor, wholesaler, or manufacturer places a defective product in the stream of commerce. It was defective when it left their hands. It could be a warranty claim, express warranties, failure to warn, or inadequate warning. It could be implied warranties, the warranty of merchantability or fitness for a particular purpose. It could be a design defect claim where you'll consider the balancing test, whether the utility of designing it one way is outweighed by the benefit, let's say, of designing it the other way, and you'll consider the availability of alternative design. It could be a manufacturing defect where the design was proper, but one of them, let's say, was made differently. Remember the concept of a component manufacturer? Like if I manufacture a part properly and give it to Tommy, and then Tommy puts that part in the wrong place, I will not be liable. I gave him the proper component. He just misplaced it. So it has to be placing a defective product. The product wasn't defective when you put it in the stream of commerce. So these are things where you'll be held strictly liable for products liability. design defect, manufacturing defect, implied warranties, express warranties. Yeah. When it comes to strict liability, you're also strictly liable for wild animals or inherently dangerous activities. When it comes to inherently dangerous activities, it has to be the dangerous propensity. Like if you slip on the oil or you slip on the chemicals, it's not that. If you ingest the chemicals, it's that, right? The toxicity of the matter. So strict liability, in particular, products liability is tested heavily. And what do I always say is a beautiful statement. I mean, you don't have to say these words in the test, but I just say it to my students because I think it rings loudly. Whenever there is an argument for a strict products liability case, there's a contemporaneous argument for negligence. Strict liability, la-di-da-di-da, design defect. Alternatively, X could argue that it was negligent for Y to design it this way, considering that P designed it that way, he had a duty to design it this way, breached that duty, causation, damages. You should always be writing about negligence. So you have, I told you defamation is key, products liability, strict liability is key, and then the other one, premise liability. That's a golden 2 words right there, premise liability. That should have been someone's name of their album. We could have had a whole album, but I'm obviously, I expected more participation on the album front this administration. That's the only time you let me down. But other than that, you guys have been the best staff, the best class ever. My staff, they never let me down. They're perfect. Okay, you guys don't let me down either. You're all perfect. Perfect, perfect, perfect. So anyway, premise liability. I love that term because people don't use that term of art. Premise liability, where if there's a land, land, and you have a trespasser or a known trespasser, or unknown trespasser, an invitee, licensee, like that's a whole essay. But you got to start with the premise liability as your issue, right? Like that's the heading, premise liability. I like that term. Make sure you can write those 3 essays well. Premise liability, defamation, and products liability. Make sure you know all the intentional torts. Make sure you know negligence. Make sure you know the 3 statements of law that I told you about torts, where we are a modified comparative negligence state. We've abolished joint and several liability, and punitive damages are limited to 3 times or $500,000, the greater of the 2. Maybe you get into a little medical malpractice issue. Just know that they have to provide notice. They have to get a third party to certify the claim that it's valid. They have a process of arbitration or mediation, and damages are limited. I don't want to get into the nitty gritty there because it's very rarely tested. Survivorship claim versus wrongful death claim. Survivorship claims are claims that linger on behalf of the estate. Wrongful death claims are claims that are brought on behalf of the deceased for the reason he died. It's kind of like the civil homicide almost, or civil, I don't want to say manslaughter. I'd say civil manslaughter almost, like wrongful death. It's less than manslaughter. It's not even a crime. It's civil. That's wrongful death. Wrongful birth versus wrongful life. Wrongful birth, that act will be brought by the parents. Wrongful life, that act will be brought by the child. Torts. Slip and falls, bananas, the old classics. What was it last time? Oh, respondeat superior, vicarious liability. Make sure that's on your agenda, right? Frolic versus the detour. You know what I'm saying? Like, look what I do. Mentally, I know everything I'm looking for, so I just find it. That's what makes me a great essay writer. Also, I'm fast, quick, articulate, good vocabulary, handsome. No, I'm just kidding. But these are the characteristics that make a really good essay, is like you can just know what you're looking for and find it instead of read it, think about it. And you know what I mean? Like you should really be actively issue spotting. That's why I did this drill with my boot camp yesterday, which is, look, I'm going to give you 3 to 4 essays, spot as many issues as you want. And then we'll see who spotted the other. And they were all mad at me. Like, how do we know who spotted those issues? And I was like, I tricked you. The Starbucks cards are going to the MBE winners anyway. But whatever. That's what we do. We trick people. But yeah, I want to get people to issue spot, because issue spotting is key. And the more issues you can spot, the better you'll do. How do you spot issues? By anticipating the issues, right? That's as simple as it is. Like Tom Brady is not that athletic compared to other people in the NFL. Why is he so good? And Peyton Manning, why are they so good at quarterback? Because they know where the blitz is coming. They know where the defender is going to be. So all they got to do is, ding, they make it look easy. I made this look easy. I bet you're like, wow, Andrew, you just made that look easy. You just said all contracts and all torts, and you didn't even break a sweat. Like, actually, I kind of literally did. It's hot out here. But like, you know, I made it look easy. Is it that easy? No. But if you study my questionnaires and you have them memorized and you can articulate them, you'll be able to do exactly what I just did. All right, let's look at an essay, a couple of torts essays. I might have missed something, but I do need to get my dog some water. Biscuit, what are you doing? He's drinking out of like the plant water. All right, so this essay, we have a jogger and they're jogging. But you have water right here. Dogs, man, dogs will be dogs. All right, so now he's drinking that good water. So a jogger was jogging. There's a dog. It's funny. So this is an outstated essay, right? Florida has abolished the one bite rule. That's what I'll take from this. I don't even want to go over this essay because I think they're going to tell us inaccuracies of law. But Florida has abolished the one bite rule. If your dog, you're not strictly liable for your dog unless your dog has known dangerous propensities. All right, so this is classic supermarket slip and fall. I know this essay well. It was negligent on everyone. It was premise liability, licensee, invitee. Florida doesn't really have a distinction, but they do recognize a licensed invitee, which has a slightly higher designation. If what I say confuse you, you could just go with licensee and invitee, but that is technically correct. Your duty to who they are and what there is. Just know if they're conferring a commercial benefit, there's going to be a higher duty, a heightened duty than if they're just there's a social guest. If they're a trespasser, there's going to be a higher duty if there's a known trespasser versus an unknown trespasser. Try to keep things, in a hierarchical form. Whatever. Try to keep things in a hierarchy in your mind, and also, write both sides. A will argue that B was a trespasser. B will argue that they're not a trespasser because the sign said they could come in, whatever. So they slipped and fall. And now intervening, superseding liability. That was important. We didn't really talk about that. That's definitely coming up. Whether there was a superseding cause, an intervening cause, know that intervening will not cut off liability, but superseding will. Just talk about foreseeability, whether it's likely foreseeable that this would happen, but that would happen. We could talk about contribution versus indemnity. Think about indemnity as someone else pays the totality of the damages versus contribution, someone pays a portion of the damages. Think about that, assignment, comparative negligence, all these types of things. It's going to be a very interesting essay because they changed a lot of laws from February to July. In my 7 years of doing this, I can say without doubt that they've changed the most laws. It's, I don't want to say anything political, but it's definitely the governor who's facilitated rapid changes. And you as students are required to know the most updated law. Thankfully, we have Amy, who is a family law attorney. She provided that in the Telegram chat, some of the updates, but we spoke about what they are. We understand the updates from torts. We understand that they moved the trust to vest now to be 1,000 years. I mean, just little things that they changed that we just want to be on top of. All right, this seems to be a totally mislabeled essay, which is not anyone's fault. Let's see this one. Alligator County. I told you guys the difference between alligators and crocodiles. What a great class this has been. So what's happening here? It's a memo. I like this. This memo will discuss the cause of actions, et cetera, et cetera. Duty, breach, causation, damages, foreseeability test, blah, blah, blah. One thing, respondent superior. One thing that I just remembered I should talk about, negligence per se, right? If you are negligent via a statute that determines what the duty of care is, for instance, a speed limit or, a criminal statute that says you must have sprinklers. Like any statute that defines a duty can be used in a negligence per se argument. Negligence per se can definitely be tested, and it makes me think of slander per se, right? Whatever, ADD works wonders. Negligence per se, slander per se. Slander per se is a type of defamation that damages are presumed. The mnemonic is club. Crimes of moral turpitude, loathsome disease, a women's chastity, or about someone's business, right? We're going to make sure that we know all of these little thingies. Okay. Intervening versus superseding. Let's see how they discuss this. In defense, they will argue causation on the theory that there's an intervening act, the negligence of the other driver, which absolves T of liability, that is foreseeable, They have to use comparative negligence. I mean, they don't really talk about it that well, to be honest. But we understand intervening versus superseding and how it could cut off negligence. It all talks about foreseeability, and we could talk about shared liability. In Florida, here we go. I love this. In Florida, you better write that like 10 times. You better write that like 10 times in your essay. In Florida, there's a rebuttable presumption that one who rear ends another driver is negligent. However, that presumption can be rebutted by proof that the rear driver did not have sufficient time to stop. A lot of times you see the model answers are obviously written by people who practice in the field, either as a clerk or as a lawyer at a state. Because I read in UBE, Bright and I read a trust essay, and we're like, yo, this person definitely does trust in the states for like 30 years, the way they wrote this essay. So don't get lost in the sauce, as I like to say. Tortfeasor is liable for injuries caused by the rescuer. Okay, rescuer. The original tortfeasor is liable for damages caused by a rescuer as a result of placing the plaintiff in the original damage. The rescuer, however, is liable for his own negligence. Well, there's no duty to render aid to an injured person absent some relationship. Once a person makes the choice to render assistance, they must do so in a reasonably prudent manner. While Florida does have a Good Samaritan statute, the statute does not provide relief to a rescuer who is not a doctor in an emergency setting or a health care provider voluntarily providing care to a non-patient in an emergency. So this is some good stuff about Good Samaritan laws, the duty to a rescuer. Remember, if someone is not negligent in how they put themselves in danger, then they won't be liable for your injuries if you go to help them. But if they are negligent in how they, like if you're negligently climbing something and you fall off and I go to help you and I get hurt, you'll be liable for my injuries. But if what you did was of no negligence, then you're not liable for the injuries of the rescuer. Remember things just kind of in law, like the firefighter rule, where, the firefighter, the police officer, you're not liable for if the firefighter rescue you on his job. They said Florida does have a Good Samaritan statute, so you could talk about. And here we go, medical malpractice. This is a good essay. Let's see exactly how they wrote it. Or you got your pens and pencils out, or copy and paste buttons, or whatever. Where one sues a doctor for malpractice in Florida, there must first be a pre-suit investigation conducted prior to filing the suit. Before notice to the parties, Before notice to the parties, the plaintiff must have a doctor investigate the cause of action to determine that it's legitimate. Then the plaintiff must provide notice to all parties involved 9 days prior to filing a suit. That's what I said. They have to certify the claim, and the third party has to say there is an actionable claim. The notice must include the affidavit of the investigator. During the 90 days, the statute of limitations is told, and the defendant investigates the action and determines whether he will offer settlement, deny, or admit liability and litigate the damages. If the parties determine to litigate the damages, then they may elect to go to arbitration. If arbitration is unsuccessful, then the plaintiff has 60 days or the remainder of the statute of limitations to file a suit. In arbitration, as well as in court, there's a cap on the damages recoverable in malpractice cases. If the plaintiff decides to go to court on the issue of damages and forego arbitration, the cap is 350 as opposed to 250 in arbitration. The cap in court for a disabled person in an emergency setting ranges from 1.5 million to 500,000, depending on damages. A practitioner must show that he behaved as a practitioner in a similar standing according to a similar community standard and acted accordingly as a prudent practitioner would. Florida also takes into account specialty. Right? Now, did I tell you something earlier when I was just kind of rambling? I said medical malpractice in Florida, they need to provide notice, they need to get the case certified, and there needs to be a process of arbitration or mediation, and there's a cap on damages. Right? That's fair enough, to be honest. Like if you want to go for the highest score in the state and you're really trying to knock this thing out of the park, master this. If you're just trying to get the points, just say what I said. You said all the key points in summary. Again, that's probably the difference maker of me and the highest score ever is I don't have a photographic memory. I'm not going to say this word for word, but I am going to be able to summarize it accurately. And there is an art to that. So this essay wasn't so bad. Let's take a look at one more torts essay before moving on to constitutional law. And please don't step away or go to sleep because we're going to do real property, which I think is going to be the most important piece. All right, all-day seminar in Tampa. Does anyone want to talk about the racket, the city of Tampa and the hotel industry and the bar exam is running on the people? Or we're just going to keep that quiet? Okay, I got to keep things quiet more often. Mother comes to you, Mother Teresa, mother, what's her name? What was Kanye West's girlfriend? And Wiz Khalifa's baby mama? Amber Rose, yeah, mother. Mother comes to you to discuss legal representation. Discuss potential causes of action available to mother and toddler, their likelihood of success, and any anticipated defenses by potential defendants. So we have mother and toddler. We have an SUV, poor kid. Oh, he was hit. So there's a parking situation, Jimmy 15. It looks like responding superior to me, right? Employer-employee relationship, it looks like. Negligence, it looks like. Occasional anxiety attacks and difficulty sleeping. What does that sound like? Yeah, IED, NIED. Like they give you they tell you what you want to say. Remember what I said about torts from day one. I've been saying this forever. Throw the kitchen sink at them. Try to argue every tort that is tangentially related, even if it's totally going to fail. Drop it and explain why it will fail. Be cognizant of your time, though. Don't spend any more time on any one essay than any other. Every essay deserves its due diligence. You know, there's 3 essays. I'm one of 3 brothers. You know, I have 2 older brothers. My mom was always clear on that. Like, you know, I don't want child B to feel like they're getting more than child A, you know? That's not how life goes. Life is unfair, but on this test, let's try to stay fair and give each essay due diligence. Can you veer off a little bit, you know, 5%, 10%, 15% maximum? Maybe, yes. An hour 15 for one essay and 45 minutes per another essay is pushing it. I really wouldn't do that. If you have a time extension, use those same type of percentages. 5 to 10% is okay. 15%, any one essay, I would just move on to the next essay. Start bullet pointing and move on to the next essay. All right, so what are we talking about here? Cause of action, negligence. This is outdated law. We understand negligence. I feel like a lot of students are going to study these outlines and be like reciting outdated law. They really should update this. It would take literally one day. I could get my tutor, my intern Jacob, to do it in one day. Okay. Using Command F, right? Just Command F, comparative or pure, and change. Like it'd be so easy to do. Okay, so anyway, negligence. All right, so remember multiple negligence: negligent supervision, negligent hiring, negligent entrustment, negligent design, and then it's employee. So it's going to be respondent superior. Again, they talk about superseding. Superseding is important. Intervening versus superseding. Make sure you understand that. Here, although a tough argument to make, because in Florida, an owner of an automobile is liable up to $100,000 for any damages caused by his or her vehicle while being used by someone else. Did I ever know that? Never. Not until this very second. Am I 100% certain that's even factually true? I can't be, because this is just someone's essay, but it seems nice. I would verify it. If you're going to use that in your essay, I would verify it. I can't verify it at this moment. Negligence, right? Duty, breach, causation, damages, approximate foreseeability, comparative negligence we talked about. Legal driving age, minor, doing an adult-like activity, damages, compensatory, as well as punitive, 3 times or 500, NIED, easy essay. I'm just going to coast through one more because it's like, show me something good. Show me something good. Oh, here we go. Punching with the fist, breaking jaws. I had my boxing trainer, Angel, in here to teach you guys how to assault and battery a punching bag. Telling you, punching it. Like all I want to do when I'm between classes is go to my gym and hit the punching bag. I even have this punching bag in my house, but I like the one in my gym more because it's an aqua bag and you can do like uppercuts. Okay, anyway, so punching, assault, battery, duty, breach, causation, damages, nothing new. Sorry, Scarlett. Zoom in full effect. Actual and proximate cause, negligence. We understand negligence, modified comparative fault now. IED. She was shaken. Defamation. Here we go. Let's read this. a publication of false fact to others that concerned them and that they were responsible for it. It was false. They did not demonstrate actual damages for defamation. Oh, they would have to, because it wasn't per se. They would have to show actual damages. So this was terrible. I mean, no offense. I would have wrote way more crispy clean discussion IRAC on defamation. Like, I'm showing you model answers that I may have given not failing grades to. I would have given passing grades, but I wouldn't have given them top grades in my class. There are definitely student submissions that have been way better than this, just because the structure and the use of the IRAC form, issue, rule, analysis, conclusion, bold, you know, we always taught that. Make it easy on the reader. Don't make the reader have to search for your rules and analysis. Make it clear to them. So I like this, but I don't love it. I would have said these are all the elements of defamation. I would have talked about public versus private plaintiff. Private is only negligence. Public is malice. You know, these are things I would talk about. Maybe if it's a newspaper, 10 days to retract this thing. So NIED, battery, right? Responding superior, we talked about that. Frolic versus detour. Frolic is going off to do drugs with your friend. Detour is grabbing a cup of coffee. I had a good coffee story today. Someone had a very serendipitous cup of coffee named after them. Negligent training and supervision, right? Tons of negligent hiring. Beautiful. I'm so happy we ended on this essay. You know why? This is a classic throw the kitchen sink in them. They said everything here. They said negligence, they said defamation, NID, battery, responding superior, negligent training, negligent supervision, negligent hiring. They did a lot of kitchen sink throwing. Trash bean soup. That's what my grandma used to call the soup she made when she used to throw, I guess, a bunch of beans in a soup. Trash bean soup. All right. So torts, we feel great about. Contracts, we feel great about. Let's go into some of the other subjects. See what's going on in my chat. And I'm not going to go too long over. I'm going to be expeditious, but we only have, 4 more subjects to really think about it. All right. So you guys are talking about nose candy. All right, that's not good. Court statement. The state of Florida has abolished joint several liability. Additionally, the state of Florida is a modified comparative fault state where if you are over 50% at fault, you cannot recover. In Florida, punitive damages are limited to 3 times the compensatory damages or $500,000. In Florida, putting proper safety warnings that complies with government standard can be considered offense to strict liability claim. Nice. Thank you, Zalpa. Thank you. Yeah, Scarlett, I agree with you. You see how I corrected it? Because if you're 50.01%, then you can't be I teach math and I get stuck on that stuff too, Scarlett. We're peas in a pod. All right. Oh, you guys had a whole conversation about this. Holy moly. Good thing I didn't entertain that. Punitive damages are available to be assessed by the court for willful or wanton conduct. Yeah. Willful or wanton conduct. That could have been someone's album name. I'm not good at photo editor things. Me neither. That's why I delegate. Delegation is the key to success. I have more people working for me than I ever imagined I'd ever have in life. And all I have is a little tutoring company. Wait till I have my own law firm, financial advising company. So transitory foreign object for commercial establishments. Sweet. Nuisance, private and public, and necessity. Okay, yeah. Oh, for intentional nuisance. Cool. We're gonna have a lot of car accidents. Dude, I tried to highlight and copy from your screen share. That's not gonna work. The expert affidavit has to be from a provider in the same specialty as the defendant too for medical malpractice. Nice. SOS. Save our souls. Is that what SOS stands for? Does anyone know? F them. Making you got there one day early to make money. Make you get there. Oh yeah. I know what you guys are talking about. Like what in the world? There's a weird medical malpractice thing too, but the modified comparative negligence scheme doesn't apply to wrongful death or negligence cases based on medical malpractice. It's pure contributor for those two. Thank you, Amy. And then they charge you for Wi-Fi and the breathe tax. Contracts and torts essay with my dream come true. Please God. True. And family law. In Florida, there's a rebuttable presumption that one who rear-ends a driver in negligence, however, the presumption can be rebutted. Florida's abolished the one dog bite rule. Florida looks at the dangerous propensity. Florida's a good Samaritan statute. Once a person makes the choice to render assistance, they must do a reasonably prudent person under circumstance. For medical malpractice in Florida, how are you writing this and on your treadmill at the same time? For medical malpractice in Florida, there must be a pre-suit investigation conducted prior to filing a suit. Before the notice is sent, the plaintiff must have the doc investigate the cause of action, determine if it's valid. Then the plaintiff must provide notice to all parties 90 days prior to the suit. The statute of limitations is told while the defendant investigates the action, determines whether either will be an offer to settle, deny, or admit liability, or the party determines to litigate the damage, then they may elect arbitration. Arbitration, unlike mediation, is binding on the parties. If arbitration is unsuccessful, the plaintiff has 60 days or the remainder of the statute of limitations to file suit. In arbitration and in court, there are damages to limitations, more blah blah. All right. Am I wrong about that? SOS is not save our soul. Doesn't it mean something different? Does anyone know? Do I have to have an ADD?
Honestly, I don't know. I just think of Rihanna's song. So I'm just like,
It's
oh,
sailor
someone save
something.
me.
Sailor. Yeah, someone. It's like sailor
It's
something.
Save our ship.
Someone save me or something. I don't know.
Save our
That's what
ship.
plays in my head, but maybe I'm
Save our
wrong.
ship.
Whatever.
All right, sorry, rabbit hole. I didn't think it would be that hard. I thought it'd be a true mnemonic. Save our souls. Sending out a SOS. Yeah, no, I have a career in singing. Psych. All right, let's do some con law. Do you guys want to start, you guys, girls, non-binaries? Do y'all want to start with the federal or Florida? All right, let's do federal. I agree. All right, so if we look at federal, you know what? Let's start with this because this is con crim law. This is something that I think is overlooked. They've been testing it a lot. Fourth, Fifth, Sixth Amendment. Fourth Amendment, or right to privacy against unreasonable search and seizures. Florida has a heightened right to privacy. There's, the exceptions to a warrant, spaces, search incident to arrest, plain view, automobile exception, consent, exigent circumstances, stop and frisk. These are some of the exceptions to when they need probable cause. It has to be issued by a neutral magistrate and define what's going to be searched in the warrant. They can only search for what they're looking for. If they looking for drugs and they find the drugs, they got to be out. They can't search the basement for more. If they're looking for make an arrest and they think you have an accomplice and they go down the basement to do a protective sweep for the accomplice and they find the drugs in the closet, that's perfectly okay. Consent, I can consent to, if me and Biscuit live here together and I say, hey, you can search the kitchen, and Biscuit's like, nah, you can't. They have to listen to Biscuit. I cannot say you can search Biscuit's room. I can't say you can go search Biscuit's doghouse where he's running a criminal operation out of. All right, so those are some things about the Fourth Amendment. They can look over your property. They could fly a plane over your property and see that you're growing plants, and that's fine. They can't use some technology that's like not normal and do like infrared through your walls. They can do like a thermal scanner and say that's really hot over this neighborhood because thermal scanners, I got a couple in my closet. No, I don't, but they're relatively normal. So that's Fourth Amendment. Fifth Amendment, I always think about 5 things on the Fifth Amendment. Rosie, you're being a nuisance right now. So 5 things I can't wait for the next week when I can just cut all law jokes out of my lexicon and just be a normal person anymore. All right, but Fifth Amendment, I think of 5 things. Due process, certainly. Federal due process rights. Right against double jeopardy. You can't be held for life or limb for the same thing twice. I always think about Dave Chappelle. I plead the 5th. 1, 2, 3, 4, 5. I plead the 5th of all the ones to pick. I pick the 5th. Right, you're right against self-incrimination. The takings clause, they can't take anything from you without just compensation. And then the Miranda rights, your right to counsel before adversarial proceedings have begun. Right to counsel, right to remain silent. If you can't provide, if you don't have counsel, when we provide for you, anything you say will be held against you. Like Jonah Hill. Oh yeah, we don't like Jonah Hill anymore. Sorry, he's canceled. Literally, he's canceled. He sucks. Sorry for Jonah Hill fans, but he sucks. So yeah, anyway, that's Miranda rights. I don't like Channing Tatum either. When I was in college, I served him when I was a server at a restaurant. He was not nice nor a good tipper. Sorry. I'm allowed to not like people. But anyway, we talk about the Fourth Amendment and the Fifth Amendment, and then the Sixth Amendment. Well, one thing about the Fifth Amendment too is it's got to be custody. And it's important to note my favorite turn of law. It's important to note that you're not in custody when you're pulled over, right? Because that's just case law. You're in custody when a reasonable person wouldn't feel free to leave. And that's when they have to give you Miranda rights. And if you invoke them, they have to stop interrogation. Then there's the Sixth Amendment. Sixth Amendment will think, criminal trial. So speedy trial, confrontation clause, your right to counsel after adversarial proceedings have begun. Those are going to be Sixth Amendment type things. Seventh Amendment is, again, civil. That'd be like your right to trial federally for cases at law or that were actionable before 1790, something like that. Okay, let's look at this one, see what kind of thing they're testing. MDMA. What is that? I never went to college. I don't know anything about these things. All right. I went to college in New Orleans. So I know about everything. That's how my grandma was too. Like you couldn't slip anything by my grandma. She's like, I lived in Miami for 90 years. You think I don't know what MDMA is? I'm like, okay, grandma. Because it was the first time I went to Ultra Fest. She's like, I read this article in the newspaper. And I'm like, I don't know what you're talking about. She's like, yes, you do. And so do I. Don't bullshit with me. All right. So there are two general types of crimes that were committed: property crime and personam crime. General types of property crimes include burglary, robbery, larceny, and aggravated crimes. Burglary requires a trespass with intent to commit felony. This is easy because everyone knows crimes, but I'm just telling you they can do a criminal law essay, and this is how it would be. This is how it would go down. Florida has removed the other common law elements, such as a nighttime break and entering to be a dwelling. So we have burglary. Robbery is a theft committed pursuant to force or threat of force that is used after the threat of property itself is sufficient. The two elements must be temporal. There are also aggravating circumstances that make the robbery an aggravated robbery or armed robbery, which is a more serious offense than robbery itself. In Florida, this includes, for example, the use of a weapon to complete the robbery. As applied in this instance, the defendant attempted to purchase an alcoholic beverage. La-di-da-da. Again, I obviously I love to promote myself and my amazing resources, but I also love to give credit where credit's due. Hornsby. This guy's got to give me a shout out, man. I probably sent him a lot of business, but he doesn't even know about it. Not he doesn't give me a shout out, but he should say, hey, thank you, man. People have been visiting my site. Not him, sorry. Richard Hornsby, Florida. Really, I think this is the best resource out there for updated understanding of Florida crimes. Most people said he was handsome, but then one of my students said he's not that handsome. So, you know, the eye is in beauty's in the eye of the beholder. I think you're handsome, Mr. Hornsby. All right, so if you look at the, if you ever watched this video, if you look at the crimes in Florida, this is a great website to go through them. The one that I try to focus on for understanding is murder. Remember, in Florida, first-degree murder is going to be premeditated with malice aforethought or enumerated felony murder, whereas second-degree murder is going to be like depraved heart or, you know, accomplice felony murder, and then third-degree murder is going to be non-enumerated, non-violent felony. And maybe like felony DUI, if you've gotten multiple DUIs and now this time it's a felony, you could actually go down for third-degree murder. So back to this essay: robbery, easy money, other crimes he did, battery, assault. Like, you guys know the crimes. I don't need to teach this too heavily. Now this talks about this is how the Constitution and criminal law intertwine, and this is why it's great. Now we have Fourth Amendment, Sixth Amendment, Bill of Rights, unreasonable searches and seizures, right? Terry stops. Under a Terry stop, an officer may stop a suspect if they have reasonable suspicion to believe that a crime or violation has been committed or is about to be committed. They can detain the suspect for a reasonable period of time to conduct an investigatory detention, determine if a crime has in fact been committed or is about to be committed. They allow the officer to stop a vehicle in order to conduct an investigation to whether a crime has been committed or is about to be committed. Okay, very repetitive. As applied to this situation, la-di-da-di-da. So, you know, a Terry stop and frisk, trying to see if crime is afoot. They could do a pat down. They're really looking for weapons, you know, but if they find something and they have probable cause to believe it's something else, then they could actually seize it. It gets very gray, and I'm sure the police officers and the criminal law defendants here know how gray it can really be, which is great. It's an essay. We love gray areas of law. A will argue this, B will argue that. So here we did Miranda. We talked about that. Miranda, this is important. You must read a suspect their Miranda rights before questioning them. They can only question the suspect if the suspect makes a knowing, voluntary, and intelligent waiver of their rights. The Miranda rights require that the officer inform the suspect of his or her right to remain silent. We already did this. I already slandered Jonah Hill. But again, truth is defamation, and you cannot be talking to a woman like that, bro. Okay. Let's see. Exclusionary rule. We understand the exclusionary rule, and we understand fruit of the poisonous tree doctrine. Anything that's, you know, taken wrongly will be excluded, and anything that follows will be also excluded under the fruit of the poisonous tree doctrine. Make sure you definitely understand that. Terry stop, you know, looking for contraband, search incident to arrest exception. So again, I told you all the exceptions to the warrant: spaces, search into arrest, plain view, automobile exception, consent, exigent circumstances, stop and frisk, or search and arrest. I forget which S goes where. Here we go. MDMA. This is what we all wanted to know about. MDMA. You're only holding it for a friend. Yeah, right. I'm only holding it in my mouth for my friend. I just swallowed it to see what it would taste like. So, and that's what my brothers used to do. Like, oh yeah, Andrew, I have to eat half your candy bar just to see if it's okay for you to eat. Like, I know about that. All right, so search and seizures, easy. All right, juveniles, you guys, luckily, thankfully, you guys don't need to do dependency. Dependency sucked. I used to do it back in my day. This one right here is a federal common law one. All right, let me give everyone some of my lenses for the Constitution. And I'm gonna, try to get through it a little bit quicker also. I just want to. Federal common law, you gotta know all the amendments to the Constitution. First Amendment is freedom of speech, freedom of religion, fundamental rights. In Florida, the fundamental rights are going to be freedom of speech, freedom of religion, and freedom of religion will include the right to free establishment and the right to free exercise. The freedom of speech is content-based, strict scrutiny, content neutral, time, place, and manner, heightened intermediate scrutiny, where it has to be an important government interest, but still narrowly tailored, and it has to be a compelling reason. We have public forums versus non-public forums. Public forums just needs to be content neutral versus limited public or non-public forums just need to be viewpoint neutral. So make sure you understand First Amendment, freedom of speech, First Amendment, freedom of religion, First Amendment, establishment of religion and free exercise of religion, whereas a religion is sincerely held belief. Lemon law is touch on it, say historically, it has to have been secular purpose, no government entanglement, and neither advance nor inhibit religion. But now, due to a ruling in Maine that's uncertain, that's how you would navigate something like that. If there's judicial uncertainty about it, discuss it and navigate it, right? Your rivers, you get around these rocks, right? And then the First Amendment, also there's certain unprotected speech like defamation or fighting words, well, not always fighting words, but words that are likely to incite lawless imminent activity, obscenity, which are, expression that appeals to only the prurient interests of humanity. But nudity, for instance, is okay if it has an artistic value. So prior restraints, gag orders, these are types of unprotected speech. We usually disfavor prior restraints and gag orders. So Florida has other fundamental rights: contraception, marriage, procreation, right to raise your family, education, and those are pretty basic rights. We have the right to vote, the right to travel, the right to access courts. In Florida, the right to work is a fundamental right. These are all things that can't be impeded upon. And then your 14th Amendment and 5th Amendment due process rights are rights that cannot be infringed upon. Due process under the 5th Amendment, your federal due process right is your right procedurally to notice and hearing, and your right substantively to not be discriminated against. Equal protection, as it applies to the states, is due process in equal protection, and there's suspect classes in Florida. In Florida, there's race, alienage, national origin, and disability. Those are suspect classes. Intermediate class, gender and illegitimacy, and then rational basis is going to be everything else. There is a concept of rational basis with bite, and that just means that there's a little bit of a heightened standard of rational basis for certain matters, including sexual orientation. Remember some fundamental rights in Florida: the right to raise your children, the right to marry, the right to work, just things that you might not think of, but if they're impacted, they are fundamental rights. So we have First Amendment, second, third, this is Florida, Second Amendment could be important. The right to bear arms, Third Amendment's not. Fourth, fifth, sixth, we talked about the criminal amendments. Seventh Amendment, jury trial for legal issues. Eighth Amendment could come up right against cruel and unusual punishment. That could be one. Hey, this sounds pretty cruel and unusual. But remember, in that case, it would have to be something federal, right, under the Eighth Amendment. Be careful to distinguish between federal and state tools, let's call them tools. Like, think about that. The Fifth Amendment is a federal tool. The 14th Amendment is a state tool, if you know what I mean by that. So be careful what tool. Contracts clause is a state tool, right? The impairment of contracts clause is for the state. So there's some other constitutional concerns. I'll get there. So Fourth, Fifth, Sixth Amendment, Seventh Amendment, Eighth Amendment is cruel and unusual punishment. Ninth Amendment, I'm not too concerned with. 10th Amendment, 11th Amendment, everyone confuses them. What's the difference between state sovereignty and sovereign immunity? 10th Amendment, state sovereignty. That's police power. That's preemption. That's federalism. That's commandeering clause. That's the right for the states to pretty much act autonomously so long as they don't interfere with the federal government. I mean, it's very easy to think about that. Like, I'm very much like that with my staff. Hey, how should I tutor this bar prep student? And I say, look, this is what I do. These are the rules and expectations. Other than that, everyone's different. You got to figure out how to row you got to row that boat together and get to the end. But as long as you don't show up late, cancel meetings. I mean, I have 10 commandments, maybe let's say, but I have my rules that they must abide by. But other than that, they have autonomy. Same way with state sovereignty. My tutors are sovereign tutors. They can do whatever they want so long as they don't interfere with my perfect 5-star review on Google, right? And then 11th Amendment is going to be sovereign immunity. And that means that you can't sue a state, right? You can sue, let's say, a state agent in their individual capacity. You could sue a state for, injunctive relief or in tort reform for certain cases. But you can't just sue a state. I can't just sue the state of Florida for being too, my grandfather used to say, Miami in the summertime, it might be hot, but at least we have mosquitoes, right? I can't bring a suit against Florida for that. But hey, it's so hot in Florida. What's up? There's nothing there, but there are some things. A state can sue another state, right? Florida can sue Georgia, and then the Supreme Court will have original exclusive jurisdiction. So 10th Amendment, state sovereignty, states are autonomous so long as they don't interfere with the federal government's rules and restrictions. And 11th Amendment is sovereign immunity, where the states are immune from lawsuits by individuals. So we could skip 12. 13 is freed the slaves and actually does apply. It prevents it allows the federal government to prohibit racial discrimination, period. The 14th Amendment is very important. States, equal protection, due process. We talked about rational basis, intermediate, and strict scrutiny. Make sure you're writing all these words. All these words are coming on your federal essay. Once you've gone through the amendments, 15th is the right for others to vote. I wouldn't say everyone, because that's not until the 19th when women got the right to vote. But then there's the 16th, which is taxing and spending. And taxing and spending is going to be okay. Pretty much always from a federal lens. They can pretty much do whatever they want. Look at some issues from a federal lens. Commandeering clause, like I said, the federal government cannot force the state to enact legislation, but they can coerce them or almost bribe them, kind of give them incentives like road highway funding or whatever it may be. Ex post facto laws, they can't, this can't punish people retroactively. Impairment of contracts, the state cannot impair existing private or public contracts. Bills of attainder, they basically can't make laws that put people in jail without trial. These are some major constitutional issues. Commerce clause, right? The federal government can regulate the channels, instrumentalities, and economic activities that in aggregate have a substantial effect on interstate commerce. The dormant commerce clause, by negative implication of the commerce clause, the states can enact legislation that on its face discriminates out of state against out of staters, they can enact legislation that on its face discriminates against interstate commerce or unduly burdens interstate commerce, such as the tire example, making tires so big that you have to change them in between Florida and Georgia. that would be, I'm sorry, I just conflated two issues. That would be privileges and immunities. Privileges and no, that would be dormant commerce clause. I'm right. Dormant commerce clause is exactly that. Something that would unduly burden interstate commerce clause, like making the tires too big. It's because, or making legislation that is going to either discriminate against interstate commerce or unduly burden interstate commerce. But I did talk about the privileges and immunities clause, which is a similar concept that's directly related to discriminating against out-of-state residents. So if you charge a commercial fishing license more in Florida, that would bring up the privileges and immunities clause. If you enact legislation that makes anyone who ships oranges have to, do these certain standards, that would implicate dormant commerce clause. The beautiful thing about essays compared to multiple choice, you're going to talk about both of them. I don't think you could possibly talk about due process procedurally without talking about substantive process, without talking about equal protection. You know what I mean? The domino effect is real. If you're going to talk about commerce clause and dormant commerce clause, I would talk about privileges and immunities, equal protection too. Like A could argue this, B could argue that. You really want to talk about the most things. Federal law, I told you in torts, and the key to today is write down the things that you must write down, right? I told you in contracts, body of law, contract formation, offer acceptance consideration, defenses, and damages if we can get through them. Like there's no real major, you always have to write this, but it is like, this is an offer, this is acceptance, this is consideration, this is UCC versus common law. Like contracts is just an easy backbone subject, let's say. Torts, you throw the kitchen sink at them, but you always say that Florida is modified comparative negligence, Florida's abolished joint and several liability, and the punitive to comparative negligence ratio, right? 3 to 1 or $500,000. Now that brings us to federal law. What are some things you always talk about in federal law? First, standing. I can't tell you how much it bothers me when people don't talk about standing in one of their essays, right? Because it's like you need standing, and standing is injury, causation, and redressability. And that's like 5 points right there. There needs to be state action. Let's talk about, is the state actually involved in the matter here? There, like I said, due process, equal protection, all the amendments, freedom of speech, freedom of religion, fundamental rights, strict scrutiny, all those things come up, are important. But I'm talking about standing. I'm talking about state action. These are things that people kind of miss. Encroachment. Be on the lookout for encroachment. That comes up all the time. Separation of powers, functions of the executive, judicial, and legislative. They love to just give you laws where they do things that sound reasonable, but they're really a violation of separation of powers. And we like to use that word encroachment, entwinement, entanglement. Hit them with all three, right? Like the more words you can give them, the better to really, really perform well in these essays. So that comes up a lot. Vagueness and overbreadth. Vagueness and overbreadth. Laws cannot be vague or overbroad. You can pretty much always argue that. So I gave you a really solid framework right there in my mind for federal law. Think about all the amendments to the Constitution and know them well, and that will take care of criminal procedure. Think about all the different types of groups of people and what is going to be applied to them, right? Like, I was about to say all the most offensive stuff, like I'm a comedian, but like, the young people, the football players, the religious people, the people who are over 40, the women, the men, the people who are not born in America, right? Think about these different groups of people and think about what rights they would claim under a law if they wanted to chop a law down. That's what they're going to ask you to do. They're going to give you a law and ask you to defeat it and say, what is wrong with this law? How could you correct this law? Why is this law not okay? So there's a lot of framework there for federal lens. Now, if we talk about the Florida lens, homestead exemption, sunshine law, make sure you know them cold. Homestead exemption, we're not going to be able to attach or foreclose or pierce someone's homestead. It's protected, and that's from outside creditors, and that applies to you, your wife, your kids, your husband, your kids, and your homestead is where you live, and you can only claim one homestead, right? It's where you live for most of the year, and you can only claim one homestead. And the people who can pierce a homestead are like mortgages, construction liens, like, things on the house itself. Uncle Sam, right? Like the government and taxes. These are like, judicial decrees, taxes, or actual liens on the property, mechanics lien, construction lien, mortgages, things like that. Okay, so that's the homestead exemption. Homestead exemption is actually also a tax deduction, which I take every year. And once you do it once, it automatically does it for you, just so you know, you don't have to fill that form out every year. But basically, you can claim a homestead and you could take, I think now it's three $25,000 deductions off of the value of the appraised value of your house. So that's homestead exemption. Then sunshine law is a right of access where all governmental proceedings will be in the sun. So the public has a right to minutes, notes, communications, and things of that nature. An exception would be if it's less than 3 legislators, not including the governor, and it's a informal meeting. But look out for that. If 2 people are at the bar talking and then they're having a drink and they're like, wow, this is interesting, and they're like, hey, you know what, let's go talk about it. The second they decide to go talk about it and make it formal, it's going to implicate sunshine law. Sunshine law also implicates the defamation thing. I've seen an essay where it's like, they said this, they defamed them, they should have had a right to access, all of that. So look out for sunshine law and homestead exemption. Definitely how to enact the law in Florida. The difference between a bill and a law. First it's a bill, then it becomes a law when it's read into both houses 3 times bicameralism. It needs to have a single subject. They love testing that. Clear title, be enacted, an enactment clause. It has to be related to the health, welfare, and morals of the people of Florida. Can't be vague or overbroad. These are some factors about enacting a law in Florida that you want to consider. You want to consider if it's a general law, special law, or general law of local application. A general law is going to be laws that's applied uniformly throughout the state. A special law is a law that's applied specifically to a county or municipality. And then general law of local application, you're looking for population. You're going to argue this could be a general law of local application. This would be a special law. What's the importance of it? A special law requires a referendum or a vote, where a general law of local application is like a general law and there's no need for a vote. I know they test this a little bit, but GO bonds versus rev bonds, general obligation bonds require a vote, a referendum. Revenue bonds require feasibility studies. Is it feasible that they're going to pay these people back? So you want to know about a special session, a special legislative session. If they call it, it could only talk about the matters that it was called for unless 2/3 of both houses vote against that. That would override like a government veto. So, government special session, it's allowed to be called. They only have to talk about the things that they were called for unless they get, consent in super majority, let's say, from both houses. Florida law, constitutional law, we have a heightened right of privacy in Florida. Make sure you state that and know that. We pretty much expressly adopted the federal constitution. Florida has stand your ground laws. Florida has a whole lot of issues with it, but it is what it is, and you're gonna be confident about writing Florida con law and Florida federal law. And federal law, and look at both those angles and try to mostly recognize that they're going to give you a statute or an ordinance or a law and ask you to attack it. So let's see how they attack this one. I told you, first thing standing, then constitutional, freedom of speech, right? Freedom of religion, freedom of the press, all that kind of stuff. Possible tort claim, whatever. Here we go, Florida suit. So this is going to implicate the 11th Amendment, sovereign immunity. Presidential options, so signing or vetoing, presentment, executive branches. This is interesting. This is a very federal one. Equal protection always comes up heavily. Commandeering clause, I talked about, they can't commandeer. Very tough essay, and I'm glad that we took a look at it. Let's see another one. Let's try 2018. All right. So this essay, Take America Back, Make America something again. Let's see what we got. Standing always, you see how it always starts with standing. Sovereign immunity, talked about that. 11th Amendment. Ordinances. Oh, we didn't talk about this. The home rule power, chartered versus unchartered counties. Chartered counties can enact ordinances that do not conflict with the state, where unchartered counties cannot. And that power to enact ordinances or whatever to operate is known as the home rule power. Home rule power is a very sacred power in Florida. Also known in Florida, there's something called the Kluger Doctrine. The Kluger Doctrine allows allows Florida to restrict access to court if there's an overriding public necessity. Suppression of speech, commercial speech, vagueness, overbreath, fundamental rights. I mean, there's literally going to be nothing in this federal con law stuff that we haven't talked about over and over again because I'm pretty thorough in my discussions. All right, standing. See, they always start with standing. I swear, if you write a con law essay and don't start with standing, you're going to be sitting again for the bar. Just trying to reinforce that, and that's probably a mistimed joke. Okay, but Commerce Clause, taxing and spending power, Commerce Clause, equal protection, due process, federalism, police powers, 10th Amendment, right? Anti-commandeering. So you see all the things we talked about, no surprises there. If we look at Florida constitutional law, see what we got here. I might need a helper for the second part of class. Is anyone locked in and can maybe be the screen share if I need him to be? I mean, not the second part. We only have a few more subjects to do, but if you can, just say in the chat that you're happy to help and I'll choose you. Okay, so here we're talking about Florida con law, and what do they end up talking about? Standing. Oh my Lord, they started with standing? That's crazy. I feel like that's a wild approach to start with standing. Obviously a joke. You should always start with standing. Single subject law, we see that all the time. Access to courts, right to contract, right? We talked about that. Impairment to contracts, access to courts. The Kluger Doctrine. Look, this is a model answer, and they call it the Kruger, the Freddy Krueger Doctrine. That's not even what it is. It's the Kluger Doctrine with an L. The Kluger Doctrine is there's a compelling public necessity and other reasonable means of redress. They can circumvent that access to court restriction. Clause number 2, bill of attainder, right? You can't just throw someone in jail without a trial. Access to courts. Discrimination, suspect classes, types of laws, general versus special. See, I talked about this, general, special, general law of local application based on population. It's nothing new under the sun. Get it? Sunshine law. Strict scrutiny, Commerce Clause, due process. I'm not scared of the Constitution. Are you guys? I mean, it is a very difficult subject. I mean, this is the year I took it, February 2017. This was the hardest essay ever, except for the other essay they gave me February 2017. Like, they killed me my year. So when I saw the essays that came out last year, I was like, don't you complain to me. I took this essay year, February 2017. So here it was definitely about encroachment, right? Are they encroaching with the one officer against the other officer? There are only a handful of constitutional officers in each county. They include the sheriff, the clerk of the county court, and the property appraiser. These officers of the county, even in non-chartered county, have independent authority granted them by the Florida Constitution. Any disciplinary issues for individual officers are handled at the state level. For example, the governor is the entity that removes a sheriff. A chartered county may enact laws that alter the standard provisions of a non-chartered county, like constitutional officers. So here, this is a really, really tough one. Sunshine law, come on. Actions by any governmental entity must be disclosed to the public. Encroachment. I just feel like people miss that. It's hard to see. So you definitely want to miss it. Remember that only a county can issue ad valorem taxes. The state of Florida cannot issue ad valorem taxes. Someone's calling me. Shouldn't have looked. So mayoral appointment, right? This is going to be they mixed up separation of powers, encroachment, defamation, slander per se, defamation, newspaper, 10 days to retract the defamatory statement, like I said. sunshine law, etc. This is a really tough essay. You see how it mixed together con law, federal con law, Florida con law, and torts. I truly believe they're going to do that a lot more based on the reduction of essay subjects. It only makes sense to me that they're going to start doing, literally they could test every subject now. They can give you real property contracts essay. They could give you a torts family law, con law essay, and then they can give you I don't know, that's actually all of them. And then ethics, like literally they can, in 2 essays, they can test all 5 subjects. Because as you see, like this one, they tested family law and constitutional law. So the only reason they say it's constitutional law is because in Florida, you have a right to raise your children. Otherwise, that's just a straight family law essay. Let's take a peek at one more Florida con law essay, but I think we should feel pretty good about the con law. Always the first issue is whether they have standing, right? I'm sure whether they're standing and they their state action. Ad valorem tax, as I said, only the right, and you can't tax a federal entity, right? A state entity cannot tax a federal entity. The right to work, I said, is a fundamental right. Make sure you understand that. If you learn one thing, the right to be in a union is fundamental right. The right to unionize, right? Like you can't require someone to be in a union or not to be in a union. The bond here, this was rev bonds, bonds backed by the revenue, go bonds, general obligation bonds backed by the government taxes. See, they do test on these nitty gritty tough things. So again, due to the nature of time, I'm going to move on to the next subject. But look, whether it's enabling clause, what type of law there is, it's the same stuff over and over and over again. And the purpose of what I've done today, or what I'm doing today, is to show everyone that this stuff gets tested over and over and over again. So let's see. Holy banana peels. Let me scroll to the bottom. Can someone take over the screen sharing? I'm gonna give you this link, which is all the essays, and in just a few minutes after I read all these millions of comments, if someone, I didn't mean to send that to you, Pablo. If someone has a good computer, that's all I need, and they could take over screen sharing so I can talk, that'd be ideal. But let's see what we got in the chat. So holy banana peels. All right, save our ship. That's what we're all saying right now, right? 5th and Miranda, 6 counts for trial. Dare failed. I'm in this Netflix documentary that when you guys see come out, and they're actually filming me again next week. They just called me up and they wanted to film me again. I'm wearing a Dare shirt. So when I'm famous, I'll be in a Dare shirt. They haven't visited college campuses. I don't know who they're talking about. Miranda rights, disability in Florida. For essay tips, you know more than you think you know. Iraq. Here we go. Coach Carter. Just disability. A matter will be justiciable if the plaintiff has standing. The case is ripe, not moot. That's important. Past harm isn't capable of being redressed. That's important. Ripe, not moot. And there's state action. In order for plaintiff to have standing, the plaintiff must prove the following elements: injury, causation, redressability. Florida Sunshine Law. Florida's Constitution guarantees that meetings of public bodies at which official acts or public business of the body are to be taken or discussed shall be open and noticed to the public. This explicitly applies to the county government bodies. This provision is self-executing and provides for exemptions only by 2/3 vote of the legislator. Further, the Florida Constitution provides that the legislator may enact a statute that exempts certain items from disclosure as public record, so long as the law states with specificity the public necessity justifying the exemption is no broader than necessary to accomplish the stated purpose of the law. Homestead exemption under the Florida Constitution, exempt property includes homestead. To qualify as homestead property, the real estate must be the primary residence of the owner or another person who is legally and naturally dependent on the owner. Up to 160 acres outside a municipality, I should have mentioned that, of course, and up to a half acre inside a municipality may be claimed as a homestead and offers certain protections. A homestead property may not be divided if a spouse or minor child survives the owner. Instead, the spouse has a life estate in the property and children receive a remainder. Okay, you can get $1,000 for personal property. Ad valorem taxes only by the county, not by the state. 2 times $25,000 exemption. I know there's something about it going up to $75,000 and from 50. I know that it used to be a 2 times exemption, but I do think you get $75,000 off. Maybe it's not homestead, maybe it's something else. Maybe it's school board taxes, but you can take $75,000 off your home. I only know that because I have it home. All right, Florida access to courts, Kluger doctrine, mortgages, mechanically lien, tax properties. I feel like we will hear that in our heads if we open the essay and it's con law. Yeah, standing. Florida con law, homestead, and family law. And then I sent someone the drive. Who minds being my helper? Hey Lexi, do you mind being the screen share? You seem like you're paying attention today.
Yeah, I can do that.
All right, so what I'm gonna do is give you give all participants the ability to share screen. And if you can just click that link, you could be the screen share, but don't start yet. I'll tell you when I want you to start.
Okay.
So before we get into real property, kind of always, take a little breather, like refresher. We did contracts, we did torts, we did con law. We know from contracts, we have to do the whole analysis of is there a valid contract all the way down to damages. We know if there's torts, we're going to throw the kitchen sink at them. And there was those 3 elements that I said I really want you to recite on every single essay. We know if it's con law, it's a lot of things they could throw at us. It could be a criminal law where you need to know burglary versus robbery versus larceny versus whatever. And actually, I kind of confuse you because Florida kind of just says theft. But anyway, go on Richard Hornsby and know the crimes in Florida. Then we talk about con law as a crim pro, 4th, 5th, and 6th, Miranda, Terry stop. I think 6th Amendment right after counsel, warrants, probable cause, all those things coming up. Fruit of the poisonous tree, there's that whole thing. Make sure you can run through that. I think the big thing to know is the SPACES acronym. That helped me a lot. Search, incident, arrest, plain view doctrine, automobile exception, consent, and stop and frisk. Then we talked about con law as a federal lens. You got to know all the amendments to the Constitution, all the fundamental rights, be able to be conversant in strict scrutiny versus intermediate scrutiny versus rational basis, know about other federal considerations like the Commerce Clause, the Dormant Commerce Clause, the Commandeering Clause, ex post facto laws, contracts, paragraph of contracts, and Bill of Attainder, just a whole bunch of privileges and immunities. Know those federal considerations. I know the Florida considerations, especially how to enact a law in Florida, homestead versus sunshine, general law versus special law versus general law of local application, and really everyone, vagueness and overbreadth, all that stuff, but also be on the lookout for encroachment, right? Some separation of powers issue. I really hope people are paying attention. I know it's hard, but I'm saying some good stuff. All right, now we move on to the topic that I think is going to smoke people this time, because they didn't do it last time and they love doing it, and it's not an easy topic by any stretch of the imagination, which is real property. Let me swig my non-alcoholic cranberry juice. Okay, so real property is very much like contract law at its core. There needs to be a written contract, right? It's part of real property. There also is the concept of a deed. Will the contract merge into the deed? A deed has to have, description of the land and the parties who are involved. And there's different types of deed. There's a general warranty deed, there's a special warranty deed, and there's a quitclaim deed. You got to know the 6 covenants of the general warranty deed: the right to convey, the right against encumbrances, and the right of size. And those 3 deeds, those 3 covenants are present. Once the deed's been recorded, they disappear. And now you only have the future warranties, the further assurances, general warranties, and quiet enjoyment. So definitely know deed formalities. It needs to be signed and attested by 2 witnesses. It has to be actually delivered. So know about recording statutes in Florida. Florida is a pure notice state where a subsequent bona fide purchaser will prevail. What is a subsequent bona fide purchaser? A bona fide purchaser is someone who takes for value without notice in good faith. What is notice? There's different types of notice. There's actual notice and constructive notice. Constructive notice, and if your other professor says it differently, it's fine. This is how I say it. Constructive notice is inquiry notice and record notice. Inquiry notice is like there's something on the property, you should have seen it. record notice is it's in the records. Actual notice is like you literally had notice, you knew about this. So big things from Florida real property law off the bat that we must know. We are a pure notice jurisdiction and we are a lien theory state. What is a lien theory state? A lien theory state means an encumbrance on the property will not sever joint tenancy with right of survivorship. A lien on the property will not attach to the property after the death of the person who, let's say the mortgagor, right? So if someone dies and they had a lien on it, can they collect from the other person? The answer is no. So make sure you understand tenancies. Tenancy, we have tenancy in common, joint tenancy with right of survivorship, and tenancy by the entirety. Tenancy in common is what's presumed. That's where if one tenant were to die, his heirs would take his portion. A tenancy with right of survivorship means that if one tenant dies, the other tenant will survive them. There has to be explicit words of survivorship. Remember, a JTROS or life insurance policy is more has priority over a will. If there's money that's devised, or if there's property that's devised in a will, or it's a JTROS, the JTROS will prevail over the devised. A tenancy by entirety is a JTROS with the element of marriage. What are the elements of a JTROS? T-tip, time, title, interest, and possession. So how do you turn a JTROS into a tenancy by entirety? You just do it, because there's no need for a straw man in Florida. Florida has eliminated the need for a straw man. A straw man used to be you had to convey it to a third party who would convey it back so that you can satisfy that element of unity of time. But Florida's eliminated that need for a straw man. So we talk a lot about contract merging with the deed, know the theory of equitable conversion, where after the contract, but before the closing, during that period of escrow, the risk of loss goes from the seller to the buyer. So if the buyer, if the house were to burn on fire and the seller, and the seller stopped his insurance, the buyer would totally be liable for that. So we talk about equitable conversion, merger of deed. We talk about deed formalities. We talk about joint tenancies, types of tenancies, and notice, pure notice. All these things are very, very important. Lien theory state and pure notice jurisdiction. It's also important to note, right? Different types of encumbrances on land, right? Like an easement versus a license. What's the difference between an easement and a license? Well, an easement is a right of use that runs with the land. A license is just temporary. A license is like having a ticket to a football game. An easement is like being able to cross over this person's lands all the time. What are different types of easements? Express easements versus implied easements. Express easements are expressly stated, written usually. Implied easements are like an easement by necessity, and something that just arises, or an easement by prescription maybe. There's easements in gross and easement appurtenant. Easement in gross is like a personal easement, where let's say utility company has an easement, whereas an easement appurtenant, there's a dominant and servient estate, and the dominant estate is burdened by the easement that runs over it. So if you have easement appurtenant, you can form it in different ways. One way is an easement by prescription. Easement by prescription is a lot like adverse possession, where you are acquiring it just via hostile use. So the statutory period for prescriptive easement in Florida is 20 years. And the statutory period for adverse possession in Florida is 7 years. And you can also have this concept of tacking, where if some person starts, adversely possessing land, they could tack on. But we'll get to adverse possession. We're stuck on easements. So easements, easement by prescription, easement by necessity, when one piece of land is hemmed in and there's no way to access a public road, or an implied easement where there was a piece of land that had an easement and then it got separated, and now it's implied that you can still use that same easement. So easement by necessity, easement by prescription, express easement, implied easement, easement in gross, easement impertinent, negative easement. We don't really recognize too many negative easements in Florida, like no light or air, but for water, riparian rights. There's the reasonable use theory and the natural flow theory. You can't really restrict your neighbor's reasonable use of the water. Easements run with the land, right? So if one person has an easement, the next person buys a land, there's an easement, it'll run with the land. There's a duty to deliver marketable title though. So if you have a piece of land that has an easement on it and you try to convey it, that's actually not marketable title. So that's definitely a consideration. Just give me 1 second. I'm going to switch. I'm going to appear twice.
Recording in progress.
Can everyone still hear me now? All right, cool. That was smooth, right? Just like, all right. So we talked about easements, easement by prescription and easement by necessity, easement in gross, easement of pertinent, express, implied, and we're familiar with different types of easements. I also talked about how you can acquire property. Well, you usually acquire property via a deed. But if you don't, you could acquire it via adverse possession. Now, be careful for this concept. In Florida, you can acquire with color of title or without color of title, adverse possession. In Florida, acquiring adverse possession with color of title means that you have some instrument that purports title. You have a defective deed, or someone gave you a deed, but they didn't have the authority to devise it to you. That's color of title. Without color of title is just a straight up, you're a squatter. You've been squatting there. The difference between with or without color of title is without color of title, you had to have actually paid the taxes on the property. Either way, in Florida, you have to have made some improvement to the land. Ideally, you'd like to fence in a property. Here's a good example, though, of a difference between with or without color of title. If you have color of title, you have an instrument that says you have rights to the land. And let's say you build a fence over half of the land. With color of title, you adversely possess it, you'll get the entire land. Without color of title, you have no deed or thing that purports it. You'll only get the portion of the land that you've made use of and enclosed. I know that's real nitty gritty, but that's with or without color of title. With color of title, you will adversely possess everything that was included in the defective deed. Without color of title, you'll only possess what you had enclosed or made use of, and you need to have paid the taxes on the property. Remember, adverse possession in Florida, 7 years, and that definitely comes up. You'll argue both ways. They acquired it via this way. On the alternative, they'll argue they acquired it via adverse possession. You'll be on the lookout for like an essay that says 9 years, right? Like they're not just going to tell you someone was living somewhere for a certain number of years unless they want you to think about adverse possession or prescriptive easement. So some other things you could talk about in Florida real property would be like real covenants and equitable servitudes. These are promises on land. Real covenants are remedied by monetary relief. Equitable servitudes are going to be remedied by injunctive relief. For them to run with the land, there needs to be intent, notice, touch, and concern the land. And for covenants, there needs to be privity, horizontal privity, always, and then vertical privity for the burden to run with the land, but not the benefit. And that actually requirement has been a little bit relaxed when it comes to privity on both amounts. But just know that there's a privity requirement for covenants to run with the land, not with equitable servitudes. Covenants are remedied by legal relief. Equitable servitudes are remedied by injunctive relief. So make sure when you're going through a real property essay, you're first looking at the conveyance. How did they acquire rights in the property? Was it maybe, they'll have you talking about fee simple determinable, condition subsequent, condition to subject to condition subsequent. Maybe it'll be one of those things, but I doubt it. Maybe they'll implicate rule against perpetuities. No interest in land is valid unless it must vest within 21 years of the death of a life and being at the time the interest was created. Like maybe, or actually vests within, you can think that was 1,000 years, it used to be 360 years. But again, they're not going to really test you on rule against perpetuity unless they
want to add just a little tiny detail that no one else is going to get. They will test you on an important Florida case. I never remember cases. I don't care about cases. Who cares? Right? These are just random names. I just want to know the rules of law. I also don't really care about what the law used to be in 1700. I want to know what the law is today, and that's it. So one case I do know of, Johnson v. Davis. That's a very important Florida case because it's used in a lot of states, which basically says that there's a duty for sellers of residential real property to disclose known defects and latent defects that they knew or should have known about. You don't necessarily have that duty in commercial property, but you certainly have it in residential real property. So know about that duty to disclose. Look for a misrepresentation claim, a fraud claim, or some sort of concealment, Johnson v. Davis claim. That's a good real property issue. Landlord-tenant comes up a lot. That should be an issue you could just breeze through. To me, that's like writing a family law essay. We're all part of families, and we've all been either landlords or tenants, probably mostly tenants, right? So we understand that whole relationship and just what they need to do. Think about the duty of habitability and quiet enjoyment. Think about maybe a nuisance claim and what the rights are. Just make sure you feel confident about landlord tenants. I could go into a whole speech about what the duties are and what needs to happen, but it's pretty self-explanatory. You can have a tenancy for years, which is a specific time. You can have a periodic tenancy, which is like a month to month. You could have a tenancy at will, which means either party could leave at any time, or you could have a tenancy at sufferance, which would be like a holdover tenant. Understand the concept of retaliatory eviction, where if you have litigation against the landlord and then he sues you or evicts you, that's retaliatory eviction. That's not going to be proper. In Florida, the landlord has to deliver legal and equitable title. So not just the lease, but also they have to make sure there's no tenant who's being held over living there. Florida is an interesting state for real property. A lot of people come down here and spend a lot of money. That's why we have things like the homestead exemption. That's why we have all these formalities about acquiring property in Florida. But at the end of the day, I think real property is easy. There's not easy, but it's definitely not easy. I didn't mean that. I just mean it's manageable. You can really, if you know what's the difference between a deed and title. Title is a position of ownership. Deed is a legal document that gives you title. You can have title by adverse possession. There could be an action to quiet title to figure out who has title. There could be a partition, right? If we need to divide the property, but know that remainder men can't have a partition. You actually have to have vested rights in the property. Definitely know that one of the big duties of the life tenant or the life estate tenant is not to commit waste. There's different types of waste. There's actual waste, affirmative waste, and permissive waste. So actual waste is you punch a hole in the wall. Permissive waste is you let it rot. And then ameliorative waste, which they love to test, is you do something that benefits the property, but it's actually actionable. Then with property, huge thing that comes up is mortgages. Oh, good. I was like, Lexi, you can't leave me. I'm about to use you. All right. Mortgages. Mortgages are huge. What are mortgages? Mortgages are loans that are collateralized by property, right? So there's a mortgage, which is two instruments. There's the promissory note that, you got to pay back money plus interest. And then there's the security agreement, which attaches the property to the collateral. If they default, if the mortgagor defaults on a mortgage, the mortgagee can initiate a foreclosure action. There's certainly reasonable and valid clauses in foreclosures, like a due on sale clause or an acceleration clause. These are all perfectly acceptable. And in the case of a foreclosure, that would be the forced sale of the home. There's a equitable right of redemption before the sale and a statutory right of redemption after the sale. The mortgage will the foreclosure will eliminate junior mortgages, so they'll have to seek a deficiency action against the mortgagor. You can assume a mortgage expressly, which makes you personally liable, or you can take subject to a mortgage, which will make you secondarily liable as a surety. The only way to totally get off the hook from one mortgage to another is to have a actual novation, a substitution of the parties. brings you back to contracts. We should have talked about assignment, delegation, novation, but just no. There's always more things to talk about. I'm trying to give you as much as I can in this time frame, but I can't give you every little thing, but just know what I'm trying to do. Show everyone that you dig deep, you leave no stone unturned, and just write really, really phenomenal essays. Bright and I were going over MPTs, and we're like, how do you stand out? And it kept saying a perceptive student would note this. And I'm like, that's a good word, perceptive. Be very perceptive. Like, don't just note the thing that's obvious and that everyone would see. Try and be perceptive and attach earlier facts to it and be like, well, since this happened, I'm perceptive, and that will allow me to write about this. Florida, there's no right to view, right? That's why I always tell people, if you're gonna get an oceanfront view, you better buy it right on the ocean, because next year there's gonna be a big old building right in front of you, and that building might even have convicts who are looking at you when you swim in the pool, right? So these are some major property rights in Florida. Try and think that anything too much that I missed out on or we could talk about. Mortgages are huge. Adverse possession, easements, land sale covenant, contracts and deed formalities. These are all very important. Obviously, statute of frauds, it has to be in writing because it's contracts for land. So Lexi, do you mind pulling up some of these essays and we can go through them? I mean, after real property, all we have is family law and ethics, and I think that'll be a breeze. Those subjects, I don't think anyone is nervous about. Honestly, I might not even go over them because I feel very confident. All right, why don't you pick February 2017? Why don't you show these people what I had to go through? All right, cool. So you have the deed formalities. You have rights of survivorship. We're going to talk about what that's about. We have a foreclosure. We'll talk about that. We know it's a lien theory state, which is not going to sever the JTROS. And we know that if he dies, then he's not going to be able to recover. We see the word orally from Nancy, which means that, yikes, orally, probably not ideal. We like things written in property. She makes improvements to the house. She converts it into an office building. This is going to be ameliorative waste, right? Because even though she did something beneficial, it's ameliorative, and she's not allowed to do that. She's a life estate tenant. We know that life estate has to pay the interest on the taxes, and it has to pay the interest and the taxes, the interest on the mortgage and the taxes, where the remainder man has to pay the principal. So there's a lease. So we have a lease. So it's going to be, tenancy for years, periodic tenancy, whatever that may be. We have an attorney who's depositing things in his account. That's definitely going to be an ethical violation of commingling. Then paying taxes and getting a tax deed. So this threw everyone for a loop my year. What is a tax deed? A tax deed is basically if there's unpaid taxes on the property, you could pay the taxes in arrears and get a tax deed. So that's fair. She wants to own the property outright. She wants to evict these people. So we're going to talk about eviction, ameliorative waste, improvements to the property, foreclosure, and partition. And this one I said, we can't have a partition from remainder men. They have to have vested rights in the property. I would love to show this model answer because I think it's one of the best answers ever written. They write it in the IRAOC form. So first, deed formalities, we understand, we can kind of scroll through. It has to be attested by 2 witnesses. That's perfectly done. The next deed, they do opposing argument, IRAOC. That opposing argument is really great methodology. All right, now what interest do they hold? Obviously, they're going to be JTROS, time, title, interest, and possession. It's a lien theory state. So the mortgage is not going to sever the JTROS. That's all going to be discussed here, right? So if you keep scrolling down, they're just getting to a JTROS. Can they foreclose on the property? The answer is no, because it's a lien theory, and the encumbrance is not going to sever the JTROS, so they're not going to be able to do that. In lien theory states, because encumbrance placed on the land by one member of the JT does not hinder the other holder's interest. If the encumbered holder dies before paying back the mortgage of the lien, the creditor cannot collect from the unencumbered holder. So this is a lien theory state. All right, we can go down. I love these opposing arguments, right? Oral agreement to rent the property, no, because it was over a year, so we're not going to have a tenancy for years, we're gonna have a periodic tenancy. What's gonna dictate the terms of the periodic tenancy? Most likely the payments. You've been paying quarterly, so it's probably gonna be a quarterly tenancy, that's what I would say. Right, yeah, scroll down, she's gonna say tenancy, I like this right now, no, that's fine. So then we talk about the waste doctrines, actual permissive ameliorative, excellent, she created, permitted, she committed ameliorative waste because she built this little whatever. See, this is an excellent essay, application, opposing argument, etc. And if you keep going down, so pretty long essay. Can she evict, hold over tenant, eviction, all these things, super solid. She can evict them, ethical issues, probably gonna be commingling. And then if you scroll down, the partition, right? Judicial partition will not be allowed until the rights are vested. There's two reasons I love this essay. One, because it's so well written. Two, because it's the IRAOC method. And three, they didn't even mention the tax deed, right? Everyone my year was like, oh my God, what's a tax deed? Like everyone Googled what's a tax deed after the essay. I promise you. This person didn't even mention the tax deed. I wrote, in Florida, tax deeds are valid and enforceable. I was not wrong, and I got to hopefully I got a point on that. But it was just one of those moments where it's like, look, there's going to be something on the test, a crazy word that no one's ever seen before, and don't actually get freaked out about it. All right, let's look at another real property one if you don't mind. We'll just cruise through a couple more of these. I'll talk briefly about family law and ethics, and then we'll call it a day. Knowing Alexis, I probably have a student in 8 minutes anyway. All right, can you pick, let's say, July 2007? That was a good year for me. That was when I was like a good athlete. I was a beast. All right, so you got this farm. We've all done this essay. I've assigned this essay 100 times. Can you just scroll down to the model answer, see what things are talking about? Valid contract, statute of frauds. First, they decide it's a homestead property. If you ever see 130, 140, like if they give you a big ass number, if they give you a big number, they're probably trying to implicate something that's related to a number. Homestead exemption for acreages, adverse possession or prescriptive easement for years, they're not that tricky. Okay, so valid contracts, statute of frauds, we're all good. We know defenses to frauds. I told you in a lot of ways, this is like a contracts essay, right? These are partial performance, pays or substantially all the contract price, occupies the property or improves the property. In Florida, you need 2 of those 3 things. We can keep going. See, this is in many ways equitable conversion. I told you about the buyer, the risk of loss passes to the buyer after the contract. Homestead exemption, they definitely talk about who can pierce it, damages, etc. Know one thing about misrepresentation, there has to be damages. Notice jurisdiction, we like this. Pure notice, excellent. Action to quiet title. Anything else? Covenants, right size and right to convey, covenant against encumbrances. Right, excellent essay. There's nothing in this essay that we didn't prepare for. Can we look at another one? Why don't we pick 2008? That's the year I graduated high school. I always tell people that was the best year of my life, 2008. Hoping that I got another best year coming up. All right, let's see what's going on here. Let's scroll down. Seems to be some fraud. Let's just go to the model answer. So the conveyance, it's got to be executed in court with the statute of frauds. 2 witnesses for the deed, that's all fine. Undue influence, so these are contract offenses. We could scroll down. Undue influence, fraud, misrepresentation, and consequenceability. Told you, contracts and real property, peanut butter and jelly. Pure notice statute, actual inquiry constructive, nothing new here. Presumption of no notice, I like that. You wrote that in huge caps. Yeah, there's a presumption of no notice. So you have to show that they had notice, but if there's a big old farm on the property, you had notice of it. Okay, so if you scroll down, this is about ethical issues, notice statutes. Anything else? Nah, not so bad. I mean, look, don't sleep on ethics. We're about to get into ethics. Do not sleep on ethics. This paper is like half ethics. All right, let's look at one more real property one. How about October 2020, if you scroll all the way down? Yes. Let's see that new. So 10 years, Luis, home, 30 years, looking like a mortgage. Willa, looking like a marriage is gonna end badly. Yep, gambling. So this has a lot of family law and deed formalities. We scroll down. Okay. Someone messaged me that they have to go to the bathroom. That's perfectly fine. Just go. Okay. Keep going down. Let's see what's going on here. It looks like a lot of family law issues mostly. Scroll down, please. Homestead property. Yeah, we're fine. Deed formalities, we're fine. Nothing new. Nothing new under the sun. Okay, fee simple absolute. Let's talk about that real quick. Fee simple absolute means you have it and you can convey it. Fee simple determinable means that, or defeasible fee simple means that well, it can be either this, but a fee simple determinable is a defeasible fee, which means that there's a automatic right of reversion. Automatic reversion. Fee simple determinable has an automatic reversion where it's like so long as the property is used for this purpose, and as long as it's not used for the purposes of like I convey this property to Tommy, so long as it's not used to sell alcohol. The minute he sells alcohol, it will revert back to me. That's automatic reversion. Fee simple subject to conditions subsequent is like if I this will be used for this purpose on the condition of X, but if it's not, then I reserve the right of reentry. Exactly. Right of reentry is for subject to condition subsequent. Automatic reversion is for fee simple determinable. Okay, we can keep scrolling down. They don't really test that much. See, a no straw man is required. That was someone's rapper name last year, the straw man, to convert a JTRS into a tenancy by entirety. And then divorce terminates a tenancy by entirety and creates a tenancy in common. All right, you can get out of this one because it's mostly, oh no, a mortgagee may foreclose. Here you can scroll down to the foreclosure. You have to show that you're the owner of the property, be named in the foreclosure action. Anything else? Junior mortgages. So something that you should know, a deed in lieu of foreclosure, that will not eliminate junior mortgages. A deed in lieu of foreclosure will not eliminate mortgages. Equitable mortgage is like something that isn't really a mortgage, but in all intents and purposes, it is a mortgage. Very important. Thank you for that, Lexi. Purchase money mortgage, a PMM will have super priority. A purchase money mortgage is when you are using money and using the money to buy the property. It's like a PMSI in secured transactions. Good job. Anything else on this one? Not really. Let's go to, let's look at one more for fun. How about 2010? Yeah. Can you do a different one actually, if you go back? Let's do 2019. Yeah. You're really good at this, Lex. All right, so Sal, he owns property in real, we already did this one too, but if you scroll down, this one's talking about easements. A big word I want people to take from this is a surcharge. A surcharge is what you're liable for overuse of an easement. You can scroll down, they're not gonna ask you about promissory notes. That was back in the day, commercial paper. Here, express easement is when there's a dominant state and a specific use of the survey easement. A person using express easement beyond the stated use is liable for surcharge. I want you to use that word, surcharge with easements, deficiency judgment with mortgages. I really want you to sharpen up on using the exact words we're going to use. So they used it here commercially, but they're only supposed to use it recreationally. They'll be liable for surcharge. They're not going to terminate the easement. They're going to pay its surcharge. It's very difficult to terminate an easement. All right, can you scroll down, please? Foreclosure again, you see foreclosures, mortgages, this stuff comes important. You could scroll through this. It's just mortgages. I couldn't tell you enough. Mortgages are important. Eviction, a right to evict a tenant belongs to the estate owner. Only material breaches will permit eviction. Sure. Anything else? Easements. I'm good with this. All right. I think we're good with real property. I mean, certainly we're not good with real property. It's going to be the hardest subject, but I think I've given you enough pieces where you feel fine. So in the nature of time, I'm gonna take back the screen sharing. Could you press stop sharing? Oh yeah, perfect. So can everyone see me and hear me? All right. We talked about the big ones, and that's what's important to me. Contracts, torts, con law, real property. I gave you all amazing frameworks in my mind to address them. Please, if you do one thing this weekend for essays, it's my questionnaires. Go over those questionnaires cold so you could do what I just did. You know how I know all this stuff? I'm just reading my questionnaires when I close my eyes. I see these questionnaires and I know how to answer them. The ones we didn't do, and we'll talk about briefly, are family law and ethics. I remember from my class people saying, I'm praying for family law, I'm praying for family law. Before I do that though, I want to see if I could see some chats. Adverse possession, 7 years, prescriptive easement 20, covenants, equitable servitudes, waste, types of tenancies, different types of waste. Landlords have a duty to give actual possession in Florida. Your period will suffer, LOL. Years, periodic will sufferance. PMMs, Johnson v. Davis, decided by the Florida Supreme Court, says where settled property knows of facts materially affecting the value or desirability of the property that are not observable or known to the buyer, the seller has a duty to disclose them to the buyer. Lease pendant, a notice to everyone of pending property action, automatically removed by the court. Ariane, that's like an inside joke with us. Sham consideration, let's see if Omar said it right. Consideration that's not actually bargained for exactly. Something that is value, sham consideration will be like, we make a contract to buy a house, la-di-da-di-da, but only if you pay me $1 in consideration. It's like, come on, we made the agreement. That $1 is sham consideration. Where a court finds sham consideration, they can avoid the legal obligation because the contract does not have valid consideration. Okay, so that's another way of thinking about it. That sham consideration just doesn't count as consideration. It's not actually something of value. Right of reentry is going to be for a fee simple determinable. Priority of a PMM is going to have super priority, right? They're going to be the person who prevails. Bona fide purchasers in Florida under pure notice jurisdiction, they take for value without notice in good faith. Someone who receives a property but does not pay for it is known as a donee, right? You're a donee if you're donated the property. I just like to give everyone the exact words of law that we're going to use on test day. All right. Let me wrap things up today by talking about family law and ethics. And we don't need to go over essays because these ones are very, very similar. What I'm actually going to do is Amy, who's one of our amazing new instructors this administration, is a family law attorney. And she went to this whole family law thing. And I said, hey, what did you learn? Because there's new updates. And she learned some important things. So what has changed? House Bill 1301 removes the requirement. Actually, watch this. Sorry, just give me 1 second because I realized I could share my screen on this device. So share screen, start broadcast. Can everyone see my screen? Removes the requirement. Can everyone see my screen?
Yeah.
Yeah.
Okay. Removes the requirement unanticipated for modification, creates a rebuttal presumption of equal time sharing, and designates a move from outside 50 miles to within 50 miles of a child may be a substantial material change. Effective date, this shall apply to all initial petitions for dissolution of marriage or support connected with dissolution of marriage, pending or filed after July 1st, 2023. Okay. I'm just making sure that she didn't send me anything I'm not supposed to share. Okay. Public officials, all a civil service system must be created for state employees and may be created for local government employees. I don't think this is very that relevant. Constitutional law. General elections are held in even numbered years on the first Tuesday after the first Monday in November. A general election may be suspended or delayed due to a state of emergency or pending emergency. Other elections are held as required by law. And limitations on re-election. Florida representatives, Florida senators, Florida's lieutenant governor, Florida cabinet officers, and U.S. representatives and senators from Florida may not appear on the ballot for re-election if by the end of the current term the person will have served for 8 consecutive years. All right. Oh, here we go. Changes to alimony. So we've removed permanent alimony and added temporary alimony. There's still bridge the gap and rehabilitative alimony. support award combinations. The court continues to be permitted to award a combination of forms of alimony or forms of payment, including lump sum payments, in order to provide greater economic assistance in order to allow the obligee to achieve self-support.
So what's temporary alimony?
Temporary alimony is for a short period of time. So the way I think about alimony is this: there is bridge the gap, pendent lite, and temporary. Those are the shortest forms, right? Bridge the gap is just kind of get you through real quickly. Pendent lite is during the cost of litigation, and then temporary is for a short period of time. There's also rehabilitative, let's call it, which is similar to temporary, like it's just to get you rehabilitated. Then there's durational, which is for a duration, and then that's pretty much it, right? Bridge the gap, temporary, rehabilitative, durational, pendent lite. Durational is going to be the longest, but there's no such thing as permanent anymore. It'll only be for duration. But temporary is just going to be like, for a couple years. It's very similar to rehabilitative, but it's just rehabilitative is for the purpose of rehabbing them. Temporary for the purpose of providing short-term support. Okay, so if I go back to family law, it's not, trust me, do I think that they're going to test us on the brand new changes that occurred 3 weeks before the test? Absolutely not. That would be so cruel and unusual. That would literally be cruel and unusual punishment. That would be ex post facto, whatever it may be. What I do think is that they could test family law. So we just got to remember the nice mnemonic that one of my instructors created. JV piece with a side of mustard, right? Jurisdiction, it's got to be where one of the parties has lived for the past 6 months, or the child has lived for the past 6 months. And remember, the party that initially issued the final judgment has exclusive continuing jurisdiction over any matters related to the divorce. So that's jurisdiction. You got to go through a minimum contacts, PJ, SMJ, V is for venue. You got to go through that entire thing, where the breach occurred or where any of the parties reside, right? That's venue. So JV piece is going to be the parenting plan. Parenting plan is going to determine, who's going to have different rights and what's important. And it could have alimony, and we talked about the different types of alimony. It could have child support. It could have just different considerations about how we're going to parent the child. Remember, the best interest of the child will always prevail in family law, and we have a fundamental right to raise your children. And we want to give a 50-50 split and give visitation rights if we can. We're going to do as much as we can to foster a loving environment from both parents. Unless there's reason that they really can't happen, we're going to try and let both parents have involvement. When it comes to time sharing, we could have sole time sharing. We could have what's called parallel time sharing, is one word they use, where it's like Andrew takes care of sports, mommy takes care of math. Like we pick it based on what we're good at, or it could just be even split. Child support, there's a whole statutory guideline, and you're not supposed to really deviate too much from it. But you can really just kind of consider the factors, the length of the marriage, whether we've now moved to 10 to 20 as a medium length marriage. All these different factors, the support of the spouse, the ability for one to go to college and the other not, just do the factor test and just consider that. So JV piece is going to have jurisdiction, venue, parenting plan, equitable distribution, how we're going to devise the property. We are a marital property state, so you determine what's marital property and what's non-marital property. Non-marital property is anything that was acquired before the marriage or by gift or devised during the marriage. So equitable distribution, consider how the homestead exemption will come into play. And then A is going to be alimony, bridge the gap, pendant lite, however you say that, temporary, durational, we've no longer permanent. You're not going to retroactively take back alimony, but you could prospectively modify alimony or child support if there's a substantial change in circumstance. So we have alimony, child support, always talk about the best interest of the child, things like that. Attorney's fees, esquire fees, everything else, as Will would say, they can be contracted for, but they're typically not part of the divorce settlement. And then, D, divorce. Florida's a no-fault divorce state. You just have to prove the marriage is irretrievably broken, or one of the parties have been adjudicated incompetent for 3 years or more. They may order you to do counseling. It usually doesn't happen. What's the difference between a divorce and annulment? A divorce is like you're divorced, and annulment is like it never happened. Florida will recognize, well, that's more into wills. I mean, there's not too much. Family law, I think we could really understand. Just put yourself in the shoes of a friend, and this woman or this man is coming to you with all of her issues, and just walk her through it. Be like, are we in the right court? We're going to have to unfortunately get divorced, and this is what you're going to have to say why. And then we're going to have to go through the entire conversation of creating a parenting plan, considering time sharing, considering custody, considering alimony and child support, and equitable distribution of property. And it's just what it is. Let's talk about all these factors, and let's always consider the best interest of the child, and that should be fine. I really don't want to go into. I would love to if I had more time, but literally my MBE student's already in the room, so I'm gonna have to kind of wrap things up. But family law was not an easy subject, but a subject that everyone in class agreed is manageable. And then that finally brings us to ethics, right? And ethics is a subject that you shouldn't take lightly. Ethics is tested every year. It could come up 2 or 3 times, and it's really, really important. So when it comes to ethics, just know there's duties of confidentiality, there's duties of decorum, duties of candor, duty not to commingle. There's conflicts of interest come up a lot, and you could have a conflict of interest that's imputed on others. You could be screened out for that conflict of interest. You have just a duty to uphold the law and to not do anything that would be improprietous. They test a lot about fees, attorney's fees, referral fees, contingency fees. Know that with contingency fees, they have to be, written consent, and they have to describe in detail how we're going to calculate these fees. That's contingency fees. And then if you're going to have a referral fee, they're really not allowed in Florida unless, they get consent and they're going to participate in some involvement in the action. Make sure, duty is to the client, not to a third party, even though the third party's paying. There's always has to be signed written consent. You really want to go over the top in writing a fabulous introduction to your ethics, to your ethics statement. And you want to make sure that you address all issues. Like if they do anything that seems like they shouldn't have done it, you should talk about it, and you should recommend that they do it in a more morally upstanding way, because you don't want there to be any air of impropriety as an attorney. You want to handle things, properly. You want to make sure that your clients know that they can trust you and that you'll keep everything they say confidential. You're not going to commingle. You're not going to have any conflicts of interest. And if you do, you'll get their consent, and you'll be able to feel that you reasonably can represent this matter. And then when it comes to charging fees and doing work, you got to have a duty of competency, right? You can't just say, oh yeah, I'll take on this family law case, and you've never done family law before. And you can learn and be an apprentice and things like that. And you also can't charge exorbitant fees. My uncle has been practicing law for 60 years. He can charge a nice fee. You all, when you get into practice, you got to work your way up and charge what's reasonable to measure it with your skill and experience. And then remember, there's no such thing as contingency fees for marital matters, domestic matters, or criminal matters. I implore everyone right before the test to go over my ethics PowerPoint, to go over our ethics drive, and just really feel like if I do anything on this test, I'm really going to knock ethics out of the park, because that's where you can get a lot of points. I encourage people to even write your ethics paragraph first because it's something that just rolls off the tongue. You know, we have a great ethics statement. I think someone put in the chat, but it's just like, where do the rules of ethics come from? They come from multiple sources. You know, the creed and the oath of bar examiners, the Florida rules of professional responsibility, the codes of conduct. You really want to talk to your reader like you understand how important ethics are, and that you're going to give tons of detailed analysis about potential ethical violations here. Even if it's not an ethical violation, discuss how it might be seen that way and what you would recommend. So I think today was a super thorough class. If you can remember, we started with contracts, we went through torts, we went through con law, including criminal law, criminal procedure, federal con law, and Florida con law. We went up and down real property, and then we moved a little quickly through family law and ethics. So I hope everyone will go back and refresh those subjects. But really, I hope I left no stone unturned. We're talking about the Kluger doctrine. We're talking about medical malpractice and you know, making sure that you provide notice. I really think that essays are where I've seen my students outperform, and that has been the motto from Ibis Prep from day one. Over prepare, over perform. So keep going. You have all weekend. It's still Saturday. I would study Saturday. I'd study Sunday. Get a good night's sleep Sunday. Have a nice, chill, relaxing day Monday. Good night's sleep Monday. And then lock in Tuesday if you're taking a Wednesday. And just put your best foot forward. All you can do on test day is your best. Nothing more, nothing less. If the results come out and they're positive, we'll celebrate. If they're not the exact results you were looking for, just know that I've been doing this for a long time and I've seen people through. Sam, who's now thriving and is actually joining my staff, passed on her 5th attempt, and she couldn't be doing better in life right now. So don't rush, just do your best, stay calm, stay confident. I hope today was a valuable session in reinforcing some of the rules and exposing people to different issues you might see on the essays. And I really care about every one of you. I want to hear from you. I want to get feedback, and I want to stay in touch. So thank you all so very much for joining this course.